Good morning, everyone. We're starting our meeting we're actually not starting, but we're gonna start by making an announcement. And so I want to make sure that our folks are streaming this. I don't know do they knock once, knock twice? Is there a secret code? We're streaming it already? Okay, great. So we're gonna turn it over to Dave Snow for a special announcement before we begin our meeting.
Hi, Dave Snow, Facilities and Fleet Department, County of Santa Clara. PG&E is working on a power outage that occurred this morning. Some of their work will require this facility to again lose power. What will happen is there'll be 5 to 10 seconds of darkness and the emergency power lights will come on. But for a period of 5 to 10 minutes, it's not known exactly how long, there will not be video or microphones or anything of that nature. So this meeting may go into recess for that period of time, but that's kind of the situation as we know it now.
So we know that Supervisor Simitian is running about 15 minutes late, so I just want to apologize to all of you that we'll try to talk to him beforehand so that we can make some calls about how we handle the 15 seconds. And Dave, did you say they're going to do that within when? Do we know?
The last estimate that they gave us should be within an hour, but
okay.
Again, it's sort of a dynamic situation, so we're expecting an update from them.
Okay, thank you. All right. So what I would suggest is if anybody has a flashlight in their purse, no, I'm kidding. Just to remind you, you have your phones, but when it does go dark, let's not run amok. Just stay seated. Thank you. So we'll be starting about 10:15. So I'm just going to make this announcement again because we've had some new people come into the room. Just a reminder that the electricity in the building will be off at some point within the next 50 minutes for 15 seconds. It'll be pretty dark. So if you're snug and cozy in your spot, it might be good to stay that way. But if the lights do go off, just make sure that you're careful about where you are. We don't know how long it will take the mics really to come up. We think it could be 15 minutes, but when Supervisor Smidian comes, we'll know a little bit more about how he'd like to move, proceed with the meeting. But I just want to make sure people know that the electricity will be off at some point within the next hour. Dave, Snow, did I say anything wrong there? We're good? All right, thank you.
Good morning, ladies and gentlemen. We're going to call the meeting to order. Thank you for your patience. It is now 10:15, and apologies for the delay. Before we call the roll, I will just share with folks here in the auditorium what I think many, if not all of you know, but some of our listeners may not, which is that we're having some difficulties with our power system as a function of the rainstorm, and at some point during the course of the meeting, I understand we may briefly lose power, and if we do, we'll deal with it in the moment, and if we have to recess for 15 minutes or half an hour when that happens, we will do so. And Dr. Smith, I see you leaning in. Would you like to weigh in on this subject?
Just a little bit more information. Turns out what happened is a goose flew into the PG&E transformer, which is located in VTA property. So it was a PG&E process that was a problem. Both of our generators came up, both for the east and the west, but PG&E has to reset something having to do with the transformer, and so there will be a short transition of power. We think about 10 to 15 minutes sometime in the near, or 10 to 15 seconds sometime in the near future. So we'll see what happens.
Flexibility is key. Thank you very much. We will ask the clerks please call the roll. That is item number 1.
Supervisor Chavez. Here. Supervisor Smidian.
Here.
We have a quorum.
Thank you. The presence of a quorum having been established, we will move to item number 2, which is public comment. Public comment is that portion of our agenda set aside for comment by members of the public on non-agendized items properly within the jurisdiction of the committee. We have one card today for public forum comment, and that is Mr. Scott Largent. Mr. Largent, if you'd like to come forward. As you know, we set aside up to 3 minutes for speakers on this item.
Ready when you are, Colin. Thank you. Thank you. Good morning, everyone. Scott Largent. Well, Santa didn't show up today. It was actually the city attorney's office dropping off a morning FedEx overnight. So they send me a lot of stuff right now. I'm a big fan of theirs and them of me. You guys know I had to go to a court appearance right before Thanksgiving. They kind of derailed some things, but I was still able to make it up to Washington. I went in front of Judge Zahner, and he was pretty much too chicken to come out of closed chambers and actually look me in the eyes. They handed me the paperwork, said I had to wait till the 10th and to show cause. Judge Zahner does not want me getting on the record, kind of tearing apart the corrupt court system here in our county. I have every right to be protesting out in front of the police department, and they have now filed, I don't understand how they can file so many lawsuits, and I'm really wondering what all these people are doing over there. I mean, you would think we got homicide detectives right here, we have the sexual violence unit, we have somebody that is a janitor. A janitor is offended by me now, so because I'm exercising my First Amendment rights. I mean, this is a lot of stuff to throw somebody's direction, but I will continue to fight it. I'm not anti-law enforcement. I actually do like police officers. I like our sheriff's department a lot, and I do like almost 99% of the San Jose police officers. The problems that I have had come out of our legal community, okay? And these are the, like Victorious would say, the illness-spreading germ attorneys. And that's kind of why we started calling James the Devil Williams his new nickname. I understand what's coming out of the county counsel's office, and I do understand the garbage that's coming out of our city attorney's office. This is just sad. This is a waste of resources and time to silence political dissent. I've talked about how law enforcement got sent to my home, and I was very upset about Carl Newsel ordering this to happen. But when that order was directed out of the county counsel's office, then things kind of start to get a little fishy. Now, when I also complained about Judge Jeremiah Stupid Scott sending sheriff's deputies to my home, you got to remember, Judge Stuart Scott ordered that. Lori Smith had nothing to do with that. So we're starting to realize who the problem is in our community. Now, when Judge Lucas decided to have me arrested for using a kid's toy, she also ordered the Santa Clara County Sheriff's deputies to arrest me. Now, it's not telling them, it's ordering them to do this. They don't want to lose their jobs. They have to do what they're told to do. Now, who got me out of the pokey? Lori Smith got me out of jail. Okay? No matter how many times I criticized the Sheriff's Department in here, she still protected my First Amendment rights. No matter what I had to say, she did it. Garcia, he's not doing that. The right hand's not talking to the left hand. I got text messages, emails from Garcia wanting to be my big best friend up until today. Now, why is the city's attorney's office going after me here, yet Garcia's rolling out that red carpet for me? They're trying to set me up to fail. It won't work.
All right, thank you all very much. Let me just check with the clerk to discern that we have no more cards on this item. All right, thanks very much. Then that takes us to item number 3. And item number 3 is to approve the consent calendar and changes to the committee's agenda. And we could ask folks in the audience to keep their conversations private. It's a little, the acoustics in here are great, so we can actually hear you, which I think surprises people. But and we don't want to intrude on your conversations either. So item number 3 is the consent calendar and any changes to the committee's agenda today. And folks, I'm going to ask you to bear with me. This is going to be a little bit complicated just because our last meeting of this committee was what we call a committee of the whole, meaning in the absence of a quorum, we heard items but did not take action. And so those have been technically continued until today's meeting, where we will take formal action, or at least we expect to in most cases. I'm not going to try and parse which ones were which. I'm just going to ask you to bear with me as we go through this exercise. And a number of these will be consent because they were consent calendar items from the last meeting, or they're consent calendar items potentially from today's meeting, or they were regular items at the last meeting that we heard but couldn't take action on and can take action on today. So I'm going to go through this with my colleague, Supervisor Chavez. I'm going to see then if there's anybody who has a desire for us to keep something on the agenda. Then going to repeat. So I will repeat the list of items that are then proposed for consent before we go through and vote on those. And then I will repeat the list of items that remain for discussion so you know what's still on our to-do list for the day. All right, thank you for your patience with that. Supervisor Chavez, based on all that and looking at our long agenda today, I'm thinking that the following items are potential candidates for consent, and they are item number 9 regarding the Civic Center Master Plan, item number 10, the Fairgrounds Master Planning Process, item 13, which is the one-year status report on county comms, and item number 15, the FMC fiscal year budget, and item numbers 16 and 17, and that's the Fleets and Facilities Annual Report on County Fleet and the Banking Services Report. Would like there on item 17 to ask for a report back on the findings, just to put that out there today, and I see the staff nodding. Item 19, the Stanford in Government Annual Report. Item 20, the Master Contract List. Item 22, legislative policies, with the caveat that we always offer that approval of the policies doesn't mean that any member of our board or committee agrees with each and every policy. Item 27, which is the semi-annual report on IT projects. Item 28, Board of Plumbing Examiners, amendments to rules of procedure. Item 29, Fleets and Facilities, county parking lots. Item 30, FAF solar PV arrays. Item 31, FAF use of real estate brokers. And item 32, status of capital projects. Now, let me begin, Supervisor Chavez, by repeating those numbers both for our committee and for everyone else, and then asking you if you'd like to make any changes, either by keeping some of those on our regular agenda or by adding something else to them. Those numbers again were 9, 10, 13, 15, 16, 17, 19, 20, 22, 27, 28, 29, 30, 31, and 32.
I think that I concur with all of those. I want to re-emphasize on 17. I'm also interested in the report back on findings, and on item 9, I would like to take that off consent, or what I can just let me just tell you what I want to do, and if you feel like it needs to stay on consent, be pulled off. What I would like to ask is that as part of the Civic Center Master Plan, there is a comment there about the annex and the timing of the annex. What I wanted to be able to do was have a report back to FGOC at our next meeting on the timeline for actually being able to put housing on those sites, with a timeline and a work plan at our next meeting.
If it works for you, I'm certainly happy to leave it on consent, but with that direction for additional information, and I think the staff is here. I'm looking to see that they got that direction as well. They did. All right. Anything else then that you would like to add to the consent calendar?
No, I'm good.
All right.
Thank you.
Then the other issue is we've had a suggestion that it might make sense to take items 6 and 18 more or less together. So the other change to the agenda would be that we would take up item 18 and item 6 more or less at the same time as part and parcel of a sort of a more comprehensive conversation, if that's amenable to you as well. And then I don't see anything else that would affect our agenda here as we look at it right now. All right, then I'm going to ask for a motion from Supervisor Chavez that we place items 9, 10, 13, 15, 16, 17, 19, 20, 22, 27, 28, 29, 30, 31, and 32 on our consent calendar, with the direction provided on item number 9, the Civic Center Master Plan, as requested by Supervisor Chavez, and with the report back on item 17, banking services, requested by both Supervisor Chavez and myself. And we will also amend the agenda to take item 18 as part and parcel of the conversation on item 6.
Perfect.
We have a motion from Supervisor Chavez to that effect.
Supervisor Simonian?
Yes.
Just also to clarify, I assume that also includes 33 and 34 on consent?
Yes, then items 33 and 34, and thank you for the clarification, are items that were already contained on our consent calendar, but yes, for the record, thank you. They are also part of our consent calendar. All right. And let me just check any additional corrections, clarifications from staff. Anybody in the room who was anxious to provide comment or testimony on any of the items we're going to put on consent? Who's desperately hoping we leave it on the regular agenda so they can stick around? All right. If not, then without objection, the motion is unanimously approved. And why don't we give people just a minute, if you are here for items 9, 10, 13, 15, 16, 17, 19, 20, 22, 27, 28, 29, 30, 31, 32, 33, and 34, and would like to vacate the chambers, this would be the time. If you're here for other items, we'll get to them in just a moment. All right. That then takes us to item number 4. And item number 4 is surveillance use policies. And we have a number here today. And Supervisor Chavez, I'm going to ask that we continue some of these simply because I haven't gotten to them. But there are some where I'm ready to try and take action today if you're amenable to that. So we'll do what we can. And in some cases I have questions, some cases concerns. And I see that we have folks from the District Attorney's Office here. And they are here for items 4A through I, and if we can ask whoever would like to come down and help present, I would appreciate it. And both some questions and a couple of cases where I thought a little discussion might be helpful. And if you would all introduce yourselves at the panel there, I see familiar faces, but if you'd just introduce yourself for the record and for anyone who may be following along on the stream.
Mike Shapiro, Chief Privacy Officer.
Good morning, Rob Coelho, Assistant County Counsel.
Brian Welch, Assistant District Attorney.
Thank you very much. And let me begin with item 4A and 4B, the data extraction, examination, forensics tools and software, and then the digital recorders. I'm fine with the documents as is. Supervisor Chavez, do you have any comments or questions on those two?
I do, just more for a better understanding. It says that you want to be able to keep the data in some instances permanently and others in 75 years. And I was just wondering, is that a normal standard for keeping data now, or is that a national standard?
No, it's not a national standard. It's the data retention policy that my office presented to the board and was approved by the board. So it applies uniformly to our cases depending on the case type.
Okay, so it's an internal policy that we
Yes.
have already. Thank you. And then the other is that that you didn't speak on particular to a make and model of a particular technology, and I'm wondering if the reason for that is that you don't know it yet, or you have multiple makes and models of technology, and this was under A.
Right. No, we know the make and model. We have elected to withhold some of those details if we believed it could compromise the use of that equipment, if the detailed model and serial number were to be released.
And was that information forwarded to the board through county council? So that, I mean, I understand there might be some instances where we have some things we don't share with the public, but other things that we share with the board. Did that happen in this instance?
That did not happen, no.
All right. I think that's reflective of my thinking on a number of items and a little bit of a concern that I have. I'll just, as Supervisor Smitty goes through his questions, I'll see if there are others that pop up for me. Thank you.
And while we're doing that, Supervisor Chavez, I'm going to turn and look at the county council and ask if he could just be giving a couple minutes worth of thought about whether or not there's a way that the information can be lawfully and appropriately shared with our board in a confidential basis, so that we can assure ourselves that the information is being withheld as a matter of legitimate public safety concern and for no other reason. And I don't think anyone is suggesting that there is another reason. I just think in terms of our due diligence, that would be helpful. So I'll ask the county council to opine on that in just a minute after we get through the rest of your items, okay? And then on item 4C, which is the next one, and this is and bear with me, we have a lot of these here. So 4C, 4D, and 4E, which deal with digital recorders, GPS systems, and night vision, that deal with GPS systems, night vision binoculars, and third-party surveillance technology, all have some similar language under authorized and prohibited uses that talks about the fact, and I'm going to use the GPS tracker one as an example. GPS trackers shall only be utilized pursuant to judicial authorization, so that's pretty specific. Let me say welcome, by the way, to our district attorney, Mr. Rosen, who's joined us. Thank you. With valid consent, or in circumstance, so that sounds pretty tight initially, judicial authorization or with valid consent. But then it says, or in circumstances that under the law do not impact anyone's reasonable expectation of privacy. Now, this has been an interesting issue on GPS trackers in particular because, and forgive me, I just don't remember the case, but the Supreme Court within the last few years looked at this very issue of whether or not slapping a GPS tracker on somebody's car was a violation of their reasonable expectation of privacy. And, you know, obviously the law enforcement folks who had been doing so thought it was not, and the United States Supreme Court came to a different conclusion. So when we say, or in circumstances that under the law do not impact anyone's reasonable expectation of privacy, I'm trying to sort through, and I'm frankly a little bit anxious that that's a great big wide open barn door that would allow anyone to say, you know, we don't think anything you do in public, for example, is protected, and yet the court has said pretty clearly, in at least the case of GPS trackers, no, if at some point you're following someone's every public movement, that does raise constitutional issues. This is a little different in the case where we have something like security cameras in a secure facility, and there's talk about not putting them where there's a reasonable expectation of privacy, and then there's a reference to places like bathrooms, showers, lactation station. So that's, I think that's a little more manageable and understandable. But in this case, what's our standard for, and how could we feel confident that reasonable expectation of privacy is something that's actually understood? Is there case law on this? Is there a statute? I just don't know. Forgive me.
Sure. I mean, I think there is case law that would address it. One example would be, let's say law enforcement is using a bait car, and they put a GPS tracker in the bait car. Someone steals the car. That person would be hard-pressed to argue that he has a reasonable expectation of privacy in that stolen vehicle. So it's going to be case-specific whether we believe we need a warrant, whether there's someone we can obtain consent from, or whether it's a scenario where we don't need either and we can proceed.
So, and I know you'll understand the question. Please don't personalize it. So if we had an office that was not sensitive to people's reasonable expectations of personal privacy and not sensitive to their constitutional rights, what's to protect us in this policy from someone simply using a GPS tracker anytime they want and saying, well, you're out and about, we don't think you have any reasonable expectation of privacy. Somebody's got a backpack sitting on the floor, you slap a GPS in the pocket and off they go, and so on and so forth. But never mind just the GPS, same thing with night vision binoculars, reasonable expectation of privacy. If somebody lives out in the foothills, leaves their windshade up, walking around in a towel after they've taken a shower, and there's no other house for 5 miles around, they probably have a reasonable expectation of privacy. Now, if one of your folks is camped out with a set of binoculars, night vision binoculars, what are we thinking? Are we thinking that it's okay for somebody to be staring through the window at that point? I mean, and I'm not really so much asking about the specific cases as I'm trying to understand how do we apply the policy on a case-by-case basis so that you and your colleagues know this is an appropriate use or it isn't. That's the whole point of having a policy in place, of course.
Well, in the case of GPS trackers, they can only be used in my office after they've been signed out. So there is a procedure where the officer or the investigator will be in consultation with the supervisor before checking out the tracker. One would hope that in all of those situations, the investigator supervisor is involved in the investigation and is approving of the anticipated use of that technology. The same with the binoculars, they have to be signed out. But ultimately, we're relying on the professionalism of the officers and the appropriate training of those officers within our office so that they understand the parameters of each policy and they understand when they may be using a piece of equipment in violation of the policy.
Yeah, and my point is I'm not sure how they'll know that they're violating the policy if we don't have some greater clarity about what the phrase reasonable expectation of privacy means. And Mr. Rosen, happy to hear from you. I don't think we're going to sort this one out today on these 3 items. So what I'm going to suggest in a moment is that we simply continue C, D, and E, the third-party surveillance technology, which also has the reasonable expectation of privacy language, involves technology that is essentially on loan, for lack of a better term, from other agencies and could be any manner of surveillance technology. And again, if the point of the policy is to give the professionals some clear guidance about here's what's appropriate and here's what's not, reasonable expectation of privacy, I'm guessing that we have as many different definitions of that as we have people in the room. So, Mr. Rosen, thank you again for joining us.
Yes, reasonable expectation of privacy is not only is it a term that lay people understand or lay people have a sense of what that means, but it's a term that courts apply. And so really to answer your question about whether this technology will be used lawfully or not is a court will ultimately weigh in on that if we're using GPS trackers without a search warrant or without consent or in violation of someone's reasonable expectation of privacy. That's something that a court is going to tell us that no, you should have gotten a warrant or you should have gotten consent, and no, in this circumstance, that person had a reasonable expectation of privacy. So I think that's ultimately how this will be sorted out. And in terms of the uses of any of this technology, we're using this as part of our investigations. And certainly, if anyone in our office is using night vision, is checking out night vision goggles and using them because they want to spy on their ex, that's something that they're going to be disciplined for. But it's hard to answer the specific hypothetical question you're answering. I think what Mr. Welch is trying to say is when we're using these for law enforcement investigations, then we're going to be mindful of what the law is.
All right. Well, I think what would be helpful is if we could bring a little more clarity and specificity to the phrase and the definition, and it may be as simple as determined by case law or as consistent with the such and such amendment of the U.S. Constitution, but understanding that, as Mr. Rosen has indicated, that it's a legal term of art as well as a colloquial phrase. I think bringing a little more definition to that, and we'll ask Mr. Coelho and Mr. Shapiro to work on that with you. Supervisor Chavez, before we move on these, again, I want to be clear, it's not about questioning the professionalism or the judgment of the people using the technology. It's about trying to make them feel confident that they've got clear guidance. You can't follow the rules if you don't know what the rules are, and if you want somebody to do something, you need to make it easy for them to do it. And the way to make it easy for them to do it is to be explicit so that we don't have what my dim recollection of law school would suggest was a void for vagueness problem.
Yeah,
so.
but Supervisor Simonian, I would just add to this that in trying to come up with specific rules for a myriad of situations is much easier said than actually done. So while we do want to give clear guidance to our law enforcement officers, we need to have some humility about thinking that we can draft something with 50 words that's going to cover every situation that comes in front of them, which is why part of what we rely on is guidance that we receive from courts about case law in different scenarios and different situations. And it may be that we can incorporate into the policy language that reflects that to address the concerns that you have.
Thank you. Supervisor Chavez?
This is going to sound like a tangential question, but I'm curious about why night vision goggles fall under this policy. And I wonder, is that something that you thought they did, or did we think they did?
We have I'm going to look to Mr. Coelho, but I'm going to lead him a little bit, if I may. And that is, we had when the ordinance was originally adopted, one of the conversations we had was about whether or not it would be limited to some limited number of identifiable technologies, these three things: cell phone simulators, GPS trackers, something else. Or whether we really wanted to have an ordinance in place that covered all manner of surveillance technology, and that was what folks in this world call future-proof, meaning what happens if somebody invents a new whiz-bang next week. And ultimately, the language in our ordinance, it does both. What it says is, here are some specific things we want to be clear we're talking about, but also anything that meets this set of definitions or criteria. And then it falls on people to discuss, well, is this or is this not surveillance technology within the meaning of the ordinance? And in some cases, people were, sort of anxious about that and went to county counsel's office. So I'm guessing, Mr. Coelho, you've given this some thought as a result, and I'll turn it to you now.
Yes, I think that's accurate. The direction that we received from the committee and based on that drafted for the board's ultimate approval was a definition of surveillance technology that was, I think, to use the phrase that you used at committee initially, intentionally broad so that things that have not yet been developed do not slip through the cracks. And by defining surveillance technology as one item or a list of 5 items doesn't account for the tremendous knowledge and technology changeovers within this valley and across the world. And certainly the DA's office, the sheriff's office, and even county departments are trying to stay abreast of the latest and greatest things to most efficiently and effectively do the work. So if you like, and for the public, I'm happy to read the definition, but it's an incredibly broad
I
definition.
do understand that, and I do know that. It just surprised me a little bit because it doesn't, what I'm really trying to understand is, was this something that the DA recognized as a tool that you thought should be covered, or were you asked to cover it?
No, we did not recognize it as a tool that should be included within the definition of surveillance technology. In consultation with County Council, there was advice from County Council that we should construe those binoculars as falling within the definition of surveillance technology. So for that reason, I drafted the policy.
Thank you.
That's true. Thank you.
Thank you. So I'm going to ask that we continue items C, D, and E for further discussion on that point. And other than that issue, Supervisor, I didn't have a concern about items C, D, and E, and I just wanted to check with you before we go on to others if there are any questions or concerns about C, D, and E under item 4.
No,
Thank you.
there isn't. Thank
All right. Then that goes to item number 5, the office of the, item F under 4F. Office of the District Attorney Video Surveillance and Recording of Evidence Storage Facility. And I didn't have any comments, questions, or concerns on that. So why don't I turn again to my colleague, Supervisor Chavez.
Nor did I.
Okay. Then on G and H, which are still under the District Attorney's Office, I did have some questions, and if you'll bear with me while I flip through. So G is the access card and biometric fingerprint system. And on data retention, I just wanted to make sure I understood what the cross-reference was here. I'm looking at page 3 of 3 in the biometric fingerprint system document, packet page 73 for those who are using the packets. And it simply says under data retention, see the county-wide surveillance use policy for facility access control technology, which addresses data retention. Can someone refresh at least my memory on what that's a reference to?
Rob Coelho, County Counsel's Office. I can do that, Supervisor. The Facilities and Fleet Department drafted for committee consideration and board approval a county-wide badge access technology policy. I believe at the outset of this DA crime lab policy, it says this policy is intended to supplement the county-wide policy that relates to badge readers. And the goal from the department and that we tried to assist with was to ensure that if there were going to be differences between the crime lab specific use, retention, or anything else, it was laid out in this policy. And to the extent it was just, it's the exact same as the county-wide one that's already been submitted to the board, and I believe already approved by the full board, we would just refer to the county-wide one because there is no difference.
Got it. And so are these the standard type cards that all of us carry around, the badges that we use to access our buildings that use, if I believe I'm remembering correctly, RFID technology?
My understanding is that the answer to that is yes, but I'll defer to the crime lab director who uses his on a daily basis and can certainly provide additional detail.
Hi, Ian Fitch. I'm the crime lab director. We did a quick switcheroo there. Yeah, we use the standard cards that are used in the county. The other thing we have biometric fingerprint readers as well for certain types of facility that have evidence and firearms and drug evidence and things of that nature. So I believe this is fairly unique to the crime lab.
Thank you. Okay, thank you. That's consistent with what I thought was the case, but I just wanted to verify that. And then the next item is, after access cards and biometric fingerprint systems, is the digital and multimedia evidence unit software and hardware. And under authorized use, and this is page 1 of the policy under paragraph 2 or section 2, and packet page 78 for those who are using it. It says the DMEU tools shall be used only pursuant to a search warrant by owner consent or on abandoned property. For abandoned property, the sole purpose of the examination shall be to identify the owner of the device so that law enforcement may then get a search warrant or seek consent if either are legally required. The DMEU tool shall be used solely for finding, processing, analyzing, or enhancing evidence relevant to the specific criminal or civil activity under investigation, so on and so forth. All other uses shall be prohibited. Let me start with a question, which is, so are we talking about the ability to crack somebody's cell phone here?
Yes.
Okay. And then what we're indicating here is that that's going to be done only with a search warrant or consent if they're required. Are there circumstances under which they're not required?
Well, that's why we discuss abandoned property, and it may or may not be required depending on what the situation with the abandoned property is.
And could you describe for us what abandoned property is, just so I understand the context here?
We find a cell phone at a crime scene,
Okay,
and whose phone is it? Nobody says it's their phone. We have no idea whose phone it is, but because it was found near some criminal activity, we think it might have some evidentiary value to help us understand what happened and who's responsible.
And do I understand from reading the language here that it says the sole purpose of the examination for abandoned property, the sole purpose of the examination shall be to identify the owner of the device. So if there's a left behind cell phone, the only thing you're going to do is identify the owner, and we're sort of relying on people to follow the law at that point and not look at everything that's on the phone if they don't have warrant or consent at that point.
That's correct. And when we get search warrants which allow us to open phones and look for specific evidence, the search warrants lay out what in particular we can look for, because people's cell phones have all kinds of information on it, and search warrants are constructed specifically to comply with the California Electric Communications Privacy Act to be specific as to what we can look at on the cell phone.
Is there any way that can be enforced, Mr. Rosen? I mean, other than the honor system, basically?
Well, number one, when somebody is looking on a phone, there's a record of what is being looked at. And so if your question is there can a group of individuals engage in a conspiracy to violate the law? The answer is yes, and that's why I'm employed as the district attorney, because people do that quite often. So, but what you're relying on here is the fact that there is a record of what people look at, and if people are looking at things that they shouldn't be looking at, that's a violation of the court's order. So, and Supervisor, that's something, just to step back a little bit, when law enforcement officers get a search warrant to search someone's house for specific items or types of items, that search is limited based on where it is likely that those items will be found. And so if officers are searching in places where that item would not likely be found, that's a violation of that search warrant, and there's consequences for that. So there are mechanisms in place to require officers to follow what the directions of search warrants are, which are court orders.
And forgive me, I just fortunately don't have a lot of experience with search orders, so that's a good thing.
Okay.
But presumably that just is going to necessarily entail, if you're looking for something, looking at a bunch of other stuff that isn't subject to the search warrant to understand this isn't it, 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 oh, this is it. I mean, that's just whether you're looking through somebody's phone for the thing you're looking for, or if you're got a search warrant for somebody's home, if you're looking for a particular document, you got to look through 20 other documents. It means by definition you're looking at 20 other documents that aren't subject to the search warrant because you're looking in the right place per the warrant, but you're just going to find stuff that's unrelated.
Yes, that's correct, but that's also what the law specifically allows for.
Okay.
But the situation you're describing in terms of, say, looking at a cell phone, in some circumstances, It may be that other items are looked at on a cell phone to figure out whether that's something that we're supposed to be looking for or not. That there's also ways of searching cell phones and laptops if we're looking for specific information where we're going to search for certain keyword terms that would be necessarily limited to what we're looking for. So there's different ways of doing that depending on what we're looking for on the phone.
Got it. I don't have anything else on G or H. Supervisor Chavez?
Nor did I.
And then on item I, which is the last item in the District Attorney's Crime Lab, the security cameras, I don't have any issues with that one, nor does Supervisor Chavez. So on A through I, what I'm going to ask Supervisor Chavez for a motion on is to move approval of items A, B, F, G, H, and I, and I'm going to say that again just for the record, A, B, F, G, H, and I, forwarded to the full board for action by the board in an open public session, to continue items C, D, and E for some additional work on the language about reasonable expectations of privacy. And again, Mr. Rosen, I take your point that we're not going to be able to identify every one of the 101 different possibilities, but I'm looking for at least some better generic understanding and expectation about what reasonable expectation of privacy is. Supervisor Chavez?
Yes, moved.
So we have a motion from Supervisor Chavez to that effect. Before I second and we call it done, I want to turn back to Mr. Williams and say, is there a way we can follow up on Supervisor Chavez's question about, could we have make and model numbers in a way that doesn't compromise public safety by sharing with bad guys information that shouldn't be shared, but that nonetheless provides some assurances to the board that we know what our county, including the independently elected district attorney's office, has and how it's going to be used pursuant to these policies.
Yeah, we'll work with the district attorney's office to see what mechanism we can use to provide that information confidentially.
Sure, that's fine.
Great. Thank you very much. Then I do have a motion by Supervisor Chavez. It is to forward A, B, F, G, H, and I to our full board and to refer C, D, and E to subsequent meeting following some additional conversation in an effort to craft the language around reasonable expectation of privacies. We don't have any cards on this item, and because there are no public speakers, I'm going to say without objection, so ordered, and thank you very much for your patience working with us on this and walking through these.
Got it. Thank you.
Thank you. That takes us to the next batch here in item number 4, which are for the Office of the Sheriff, and we have the Custody Bureau, and we have Supervisor Chavez for J, K, L, and M, and those are booking photograph cameras, handheld digital cameras, inmate telephone monitoring, and portable digital audio recorders, J, K, L, and M, and I see that we've been joined. If you'll introduce yourself for the record, please.
Happy to do so. Assistant Sheriff Ken Binder.
Thank you. Thank you, Assistant Sheriff Binder. And on these, Supervisor Chavez, I'm okay on J, K, and L, and I have just a little discussion I'd like to prompt on portable digital audio recorders. But before we get there, did you have comments or questions on the?
I really just had one, and I didn't have big concerns, but I know that as part of the telephone monitoring, today we don't listen to the jail observer conversations with an inmate. Is that accurate?
I'm sorry, could you repeat the question?
Do we record inmate conversations with the jail observer?
If the jail observer is having conversations with inmates over the phone system, then yes, the only conversations not recorded would be attorney-client privileged conversations.
Interesting. And we listen to the jail observer. I don't know if there should be a different standard for that, but we've always done that. We've listened to the jail observer calls.
The system records all phone calls except for the phone numbers of attorneys and public defender's office and alternate defender's office, which are actually taken out of the system. So if there's any other type of phone call made, the system will be recording.
Oh, I didn't realize that. The reason I was asking that question is that I think I was under the impression that that wasn't the case, and so.
Okay, Supervisor, I'm being informed by Assistant Sheriff Taylor, who oversees corrections, that those phone calls are actually also not on the designated record list.
Thank you.
So it would be attorney-client and jail observer program.
So, okay, thank you. And that was actually my question. I didn't see that denoted and wanted to better understand that. And really, maybe just to follow up, if as we're doing these kinds of bodies of work, I don't know where if that's a jail policy, if that's a county policy. Some of it sounds like it would be already in the law, especially the attorney-client privilege. But is us opting out of the jail observer calls, which I think is a good idea, but is that a policy or decision that the Sheriff's Department has made?
To respect the privacy of jail observer, that is a policy that we have opted out of.
That's a Sheriff's Department
Correct.
policy. Great. Thank you. That's all my questions.
Supervisor Chavez, thank you for catching this one. And my question would be, if we looked at packet page 107, and gentlemen, for those of you, if you're not working from the packet, it's page 2 of 5 in the document on inmate telephone monitoring surveillance use policy, packet page 107, looking at paragraph C. Paragraph C is the place where the exceptions, essentially what you've said above is that every call gets monitored. And then in paragraph C are the exceptions for public defender's office, alternate defender's office, or a verified pre-registered attorney's phone number. The call shall not be listened to or recorded. And do we need to ask you to, Supervisor Chavez, to your point, should we be asking to include the observers in that list there so that the policy is clear in the surveillance technology policy that those are calls that are not listened to?
Let me just say this. I think that would be helpful. And I was even thinking that making a reference to the other policy might be helpful, right? So if you've already got an internal policy that you're just affirming a policy that you have already.
Okay, we can add the jail observer program in this list of people not to, conversations not to record.
Thank you.
Thank you. And thank you for the catch, Supervisor. And then on portable digital audio recorders, authorized and prohibited uses. So these are just what they say they are. They're recording devices. And under authorized and prohibited uses, it indicates that the Sheriff's Office portable digital audio recorders shall only be used by Sheriff's Office personnel, okay, to record verbal statements. And I'm on page 2 of 4, and I'm under paragraph or section 2, packet page 118. Shall only be used by Sheriff's Office personnel to record verbal statements of victims, witnesses, suspects, and others in criminal investigations and administrative investigations, and to record audio of incidents or events being monitored or investigated by Sheriff's Office personnel as part of their law enforcement or custody duties. And then it talks about what's not permitted. What wasn't clear to me from this was whether or not these devices are used to surreptitiously record people, or whether these are for just straight ahead, hi, thanks for coming in, Mr. Smith. We're going to sit down and we're going to record with your knowledge and or consent. So can you help us out on this? And if you want to huddle for a second, that's fine. But I'm just trying to understand does this policy essentially permit surreptitious recordings using these devices? And I don't mean to put an ick on it by calling it surreptitious. I just mean surreptitious in the sense of not being with someone's knowledge and consent.
Generally, our deputies will be wearing body-worn cameras, so there will be a non-surreptitious recording. There may be times during investigations that surreptitious recording is appropriate and allowable, so we specifically do not have the surreptitious barring language within the policy.
Okay, I think what I would like to suggest on this one then, Supervisor Chavez, is that for J, K, and L, which are the booking photograph cameras, the handheld digital cameras, and the inmate telephone monitoring, I'm ready to ask for a motion to forward those to our full board with a favorable recommendation and with the direction that staff and the Sheriff's Department will work to add the language that you've been kind enough to agree to on the Observer program, but that we continue item M, which is the digital audio recorders, to have some follow-up conversation and a better understanding, at least for me, of to what extent the tool can be used without the knowledge or consent of someone. Is that acceptable? Okay, so we have a motion from Supervisor Chavez to that effect. Before I call it a second and say done without objection, any additional comments or questions from Mr. Shapiro, Mr. Coelho, Sheriff's Department? Nope. No cards on this item, and therefore I'll say without objection, so ordered. Thank you very much. We'll follow up with you on item number M, and on the other three, we'll forward those to the board. Mr. Marquez, I think of you as the keeper of the sequencing on these. Do we know when those, the ones I'm saying will go to the board will go to the board? Will we get them there?
I think I need to turn to Assistant County Counsel Rob Coelho.
We'll have to check the current schedule. These had originally been on for the November 3rd meeting, I believe, and so we've been thrown off. I believe the earliest it would get to the board would be the second meeting in December, and it may be based on our calendaring now. These would come to the board the first meeting in January. So we'll confer with county administration, but I believe it's one of those two meetings.
Thank you. All right, then that takes us to the next batch, which is the health and hospital system. And my apologies, as I mentioned earlier, just ran out of time, frankly, to give these the scrutiny, given the number that we had stacked up, and that's on me. But I did have a couple of questions about N and O, and then I was fine with P. So do we have anyone here from the health and hospital system who can help us with this? Don't be shy. Welcome. And again, if you'd introduce yourself for the committee.
Laura Rosas, Ethics and Compliance Officer.
Thank you very much. On N, which is the baby match technology used at the medical center, you learn something new every day, which is one of the things I like about the job. And I even spent a couple of minutes online, although there wasn't a lot of information on the vendor's website, candidly. So the thing I want to ask a little bit more about on this one, and I'm at packet page 125, I'm on the first page, is what is the actual technology? Is this an RFID technology or radio frequency identification device? And my understanding is that essentially we wrap a little band around the baby on the leg, I think, and then we have a similar device on the mother, and we make sure that the baby's not going off in a direction that he or she shouldn't. But it's not really clear to me, other than the fact that there's a brand name, Baby Match, how this works. And I'm just trying to get a little better sense of what we're capturing and what we're doing with it. That's
right. Thank you. So that is correct. It usually does go on the leg. I believe it is RFID technology, but I would have to check. But I believe it triggers alarms when the baby's moved outside of a certain perimeter.
Okay, I'm going to ask that we continue this, get a little more of a sense of what's the actual technology being used, because without knowing that, I feel a little ill-equipped to then understand, so what information is being captured, and then what's being stored, and for how long?
Well, the only information that's being captured is the baby's last name, and I believe the gender. So, and that goes into a database that is then expunged upon discharged. So the device itself is linked to that last name and the gender, but it's really the point is to trigger the alarm when outside of that perimeter and then to match it back.
Okay. But of course, the other information that's being captured is the location.
I'm not sure if it does capture the location. I think it's triggering an alarm.
Okay, let's find out if we could and bring it back and both, number one, would like to know, and number two, would like some of that information folded into the policy. That's my personal request as one member of the board. And then, before we leave that item, Supervisor Chavez, anything on that one? Okay, and then that takes us to O, which is the badge and biometric readers. And on this one, I may have had my question answered on a previous item. I did not. So again, we're talking about badge readers. Are these the standard? I'm at packet page 132, first page of the badge and biometric readers policy here. Are these the standard RFID-enabled badges that we all use as members of the county staff?
That is correct.
Okay, thank you. So it says under purpose in the second paragraph, upon use, badge readers identify the individual identified on the badge, and then it says badge readers collect information such as the date and time an individual enters and exits a building. This information may be provided to local law enforcement authorities, the Sheriff's Office pursuant to a memorandum of understanding with the Santa Clara Valley Health and Hospital System, Santa Clara Valley Health and Hospital System Protective Services staff, Director of Facilities or designee, so on and so forth. And then later on, under data access, it says access to the data from badge and biometric readers shall be restricted to only Sheriff's Office personnel pursuant to the Memorandum of Understanding, Protective Service Office staff, Director of Facilities, department heads, other county personnel for county business purposes only with written approval. Effort shall be kept to keep the total number of designees. And then down under third-party data sharing, so you can see I'm bouncing around because the information is sort of embedded throughout the document. Under 8, it says it shall be permissible for data from badge readers to be provided to only the following: law enforcement representatives outside the Santa Clara Valley Health and Hospital System if the Santa Clara Valley Health and Hospital department head with oversight responsibility for this policy or a written designee believes that the data shows behavior or activity that appears to be unauthorized, improper, illegal, or in furtherance of illegal activity. So my question is, we're at VMC, for example. VMC is in the city of, pop quiz, not a trick question.
San Jose.
Great. And somebody from one of the other 14 cities, law enforcement, somebody that has their own police department shows up, and the Campbell Police Department shows up and says, "Hi, we're looking for Sally Schmidlap. What can you tell us?" What happens? How does that get processed?
I'm going to defer that to Mr. Coelho.
Supervisor, I don't know the answer to the question. It's an operational question that didn't come up in the drafting of the use policy.
Well, I'm going to ask that we think this one through a little bit more because there's a tension here that's built in between the desire and appropriate need to cooperate with bona fide law enforcement inquiries, but on the other hand, to not be sharing people's I mean, you're the HIPAA expert, I'm not, but even somebody's presence in the hospital, if I remember correctly, is a HIPAA-protected piece of information. So sharing that information with someone who shows up, with that, I think there's some challenges there, and I'd just like us to work those through a little more fully and a little more clearly. I meant to mention this when District Attorney Rosen was here. We've got these tools that are bona fide tools that in 99% of the cases plus are used appropriately. I'm thinking now of our criminal databases, and yet we know that folks from both the District Attorney's Office and the Sheriff's Office have on occasion accessed that information for inappropriate personal purposes. And to the credit of both organizations, they've been disciplined when that happens. That's what. So the question here is, how do we make sure that the information is available for appropriate purposes when needed, but also make sure that I'm just going to say it, somebody who's stalking their ex-wife or their estranged partner doesn't show up and manage to talk their way into getting identification information about the presence of someone who may be a victim of domestic violence or whatever the concern is. So I think you can see, and I know these are hard, real-world, day-to-day challenges you all face, and so I want to acknowledge that, but I think some additional discussion. Please, Supervisor Chavez.
One thing that might be helpful is when you bring that back, it's just to walk through some scenarios, because one of the things that I know that for any of us who've either been in a hospital late at night or an emergency room or been part of any, if you've ever just done a ride-along or a sit-along or any of those things in these venues, that the connection between law enforcement and our healthcare system is actually pretty profound. And I'm not sure we've actually wrestled with it. And I mean this both as it relates to when we have someone drops someone off at the hospital for either mental health issues or someone's being brought from an accident, where drugs or alcohol are considered. And so I do think it's just worth better understanding that, having some clear guidelines about how we function, and frankly what people's expectations should be of privacy in those environments. So that would be helpful. Thanks for bringing that up, Joe, the way you did. I wouldn't have thought about that.
Thank you. And then that takes us to P, which is the Fair Warning Electronic Health Record Privacy Monitoring System. And I have no comments, questions, or concerns about that. Supervisor Chavez? And unfortunately, that's as far as I got on my homework. So the question I would ask is, I think we do need to have follow-up discussion on N and O. On P, even though there do not appear to be any issues, what I'd suggest is we just sort of leave it on the to-do list so that we're not sort of piecemealing this exercise in a way that's even more confusing than it already is. And we will come back to you on the others. And what I'll work with my office to do is to finish my homework assignment, and then perhaps what we'll do is reach out to folks at Health and Hospital and or Mr. Coelho and Mr. Shapiro independently, so we can get as many of these issues resolved before it comes back to committee, and we won't have to do it in real time that way. That might be the most expeditious. And Supervisor Chavez, of course, is free to reach out from her office as well if she's got individual comments or questions. Okay?
Thank you so much.
Thank you. Appreciate your being here. All right, then Supervisor Chavez, I believe that completes what we have to complete under item number 4, and without objection, I will simply move on to item number 5, and on item number 5, that's also where I did not get to my homework, so I'm going to have to say, could we please discontinue those items without objection? And there is no objection, so we will. So now, if you're here for any of those surveillance policies, that's it for the day, for those of you who are here just for those items. That takes us now to item number 6, which is the 3 most actionable reforms to improve the hiring process. And we're going to bundle that with item 18 at the same time. And who's going to present on this? And Supervisor Chavez, I don't know if you had a chance to get briefed on our previous conversation on this, but essentially what I asked Mr. Mills to do was to come back. I would say the first iteration in my assessment was a sort of a broader look at three areas where significant change might be called for, and sort of a bigger picture view and efforts in those directions. And I asked Mr. Mills if he could come back when you and I were both here, but with something, with things that might seem smaller, but that were sort of more precise and actionable. Like, can we have a real thing we could do pretty darn quickly, and see if we could make that work. So that's, Mr. Mills, is that consistent with your recollection of the conversation?
Yes, that is consistent.
All right. So what would you, I think I'm going to turn to Dr. Smith, and he's going to turn to you anyway, but let me just double check that. Dr. Smith, is that how it's going to go?
Well, a little bit of an introduction.
Sure.
So we heard the committee asked for a focus of 3 issues. You know, there are a number of issues that could be addressed from small details to large details. All of them are interrelated with a combination of state law, local charter requirements, and contracts that we have with unions in the form of MOUs. So I worked with John Mills from ESA to develop 3 that we think are within the discretion of the board, could relatively easily be accomplished, and would significantly improve the hiring process and the speed with which it can be done. And I'll let John go through the details of how and why.
Sure. The only thing I would say before we do that is I do think the reason for bundling 18 was to sort of set the context for this. It might almost make sense, and forgive me for just saying this now, to do 18, sort of to tee up 18 first rather than do the 3 items. But I don't have a
together.
Is there a way
whatever,
to integrate
yeah.
the 2?
Yeah, I can sort of contextualize the two together. So just to follow up actually on Dr. Smith's comments and to give a little bit more background to Supervisor Simidian's introductory comments to the item. The 3 most actionable and significant reforms item was initially requested by the committee during the budget process, I believe. And we had our first sort of foray into this conversation at FGOC in August, where we highlighted the 3, as we saw them, most critical stakeholder groups to the hiring process, which are the Human Resources Department, of course, the hiring managers, and the labor organizations, and our efforts related to relationship building and culture change among those 3 entities. At the last meeting, as Supervisor Simidian referenced, we presented sort of another iteration of the 3 things, which was more focused on the efforts that we have undertaken recently related to increasing the transparency of the recruitment process for all stakeholders involved to improve their understanding. Our efforts that we've undertaken both internally and in partnership with TSS to build up our data gathering infrastructure to be able to have data available to us and to the hiring department so that we can create accountability around the process and also help us to manage the process better and see where we might be having some delays. And then the third thing that we talked about in that last report was what we refer to as the candidate experience, which is our efforts that we have initiated with departments to plan recruitments up front so that once the job bulletin is posted, the process from the perspective of the applicant is fairly seamless. As Supervisor Simidian mentioned, at that last meeting, he requested that we come back with 3 basically specific sort of action items that we thought would most significantly impact the hiring process. And as Dr. Smith mentioned, these are the three that we came up with that we internally in Human Resources believe create the most significant delays to a recruitment proceeding. Relative to the vacancy report, this is actually a follow-up report to an initial report that was requested and provided during the budget process back in June. And it just encapsulates information that we have requested and received from departments about the status of their vacancies. We've categorized them as described in the report in terms of the context of where they are in the recruitment process to respond to the question about the recruitment status of those vacancies. And we've also presented information in terms of the overall vacancies for each department, and then also we've highlighted specific departments and the reasons why some of their vacancies exist and the efforts that we're working on with each of them to address their specific situations. So if that seems adequate to the committee, that basically sort of provides the context of what brings us here to the discussion today.
Thank you. Supervisor Chavez, before we go to the three specific items, I've just got a couple of questions about the larger issue of the vacancy rates. And can you, if you can. Sure. My notes indicate that the status with the most vacancies is no request made. Could you tell us a little bit more about that?
Yes. So the no request made, there could be a number of factors sort of embedded in the no request made. The no request could,
remind us what that means. I apologize.
So no request made means that the hiring department has not submitted a request to Human Resources to initiate a recruitment for a vacant position. And
now, I apologize. I think of this as a conversation. Feel free to interrupt me because, as you can tell, I'm feeling free to interrupt you. And I really do want us to have some back and forth here. And Mr. Milson, I'm not being flip when I say I think there are times when we look at you at ESA and say, hey, how come we don't have something going on here? Why aren't we making more progress? Why isn't it more quick? And part of the answer is, well, some of it may be with ESA, but some of it's with the departments themselves. And so while you're being very gracious and professional, as is your custom, I think part of what you're trying to communicate here is you can't make the process work if somebody hasn't even asked for the position to be filled. Now, I'm putting words in your mouth. How do you feel about that?
That is true in some circumstances, yes.
I'll be more straightforward. The way the process works is that when the board creates a position and funds it, the department where the position is placed has to initiate the recruitment process by transmitting a form to ESA that basically says either give us the list of the current list of candidates or create a list of candidates or begin the recruitment for that particular position depending on the status of that particular classification. Since the hiring authority is within the department, either a manager typically or sometimes an executive, that request has to be made first. So any positions that are created and are vacant without a request fall into this group.
Well, part of the reason I'm asking the question is if I've been looking at the data correctly, it looks like there are 799 no requests made. Does that sound about right?
Yes.
I mean, I'm just...
So that's why we have said in the past, the ESA department does not hire people. It's the managers and the executives, and they have to request begin the process of hiring. So it's a little bit crazy that they're complaining of not being able to hire when they're not requesting to hire.
Well, we've also had some conversation during some of the budget processes about budgeting positions that go unfilled, and over how long a period it's reasonable for that to be accommodated, for lack of a better word. And you know, I'm sitting here thinking 799 people where we haven't even asked to fill the position. It just baffles me. I'm having trouble, as you can perhaps tell from the fact that I'm so inarticulate. I'm having trouble understanding what that dynamic is about. I don't have an opinion on it. The reason I don't have an opinion on it is because I can't understand why, you know, if there were 799 positions that could be filled, you would think departments and agencies would want to fill them and would be asking. What am I'm missing something, so somebody please tell me what it is I'm missing.
Well, and as I mentioned earlier, there are sort of several factors embedded in the no request made categorization. Some of those are certainly what Dr. Smith described, where for whatever reason the hiring department just has not submitted the request. Some of those, there is very much a reason why the hiring department is holding that position vacant. From our perspective, it could be, say for example, with the Information Technology Career Compass classification study, the department could be holding certain positions vacant because they're awaiting the outcome right now of the meet and confer with the labor organizations, because they want to be able to hire into the positions that are represented by the new job classifications, not the old ones that have been very challenging for us to recruit into. And to your point, Supervisor Smithian, about the length of time that some positions remain vacant, I should also mention that this report was a partnership between ESA and the Office of Budget and Analysis, who, as the committee is aware, conducts an annual exercise that is in conjunction with the budget process, where they bring back to the board those positions that have been vacant for a long period of time with a recommendation to delete them or retain them for some operational reason.
All right, I'm going to take a pause here to turn to my colleague who may have some. Let me just say, it's pretty rare for the two of us not to have opinions.
Yeah,
I mean it's.
So I do want to just say I appreciate the reports. I think that one of the questions we have to ask ourselves is really, in a more concrete way, identifying the problem or several problems that we're trying to solve, and then look at solutions. And I have to say that every time we have a discussion, and I feel like we're at a disadvantage here because we have you here, and frankly, we don't have department heads or managers here having a conversation about how the system could be improved. And I know you're doing some of that, but it's hard to understand that from where we sit. Oh, John, did you want to say something?
Yeah, no, I mean, just on that note, if I might, just to maybe sort of fill in some of the gaps. To your point about the reference that you just made about how we are embarking on that work, as I had mentioned in the report that was part of the FGOC agenda for the last FGOC meeting, that we have just initiated a transformation effort with the Center for Leadership and Transformation, so we're very happy to have their assistance. And we have constituted a number of teams within ESA, one of which is a human resources team specific to these issues. And we are in what the CLT parlance is sort of the diagnosis phase, which is basically an information gathering phase. And part of what that phase entails is reaching out to departments with sort of akin to customer satisfaction surveys. We're going to be doing focus groups. So to your point about how it's hard to have that conversation here, we are having that conversation all over the county. And I think we will get to a point, sometime along the CLT timeframe where we'll be able to bring that conversation here or to the board and just sort of inform you all of what we've learned and where we're going with it.
So first of all, I'm really excited that ESA, HR, and I'm assuming that's labor relations as well.
Yes, the whole agency's involved in this process.
And what's fascinating to me is that process, the whole CLT process, actually didn't start with ESA. I mean, and I know Dr. Smith brought that process on when he started, but my point in raising that isn't that it isn't to negate how important it is that you're doing it now, but that it really speaks to a bigger, deeper set of challenges within that department, that it couldn't have gone first, and it didn't want to go first, and it didn't want to go even in the first sort of phase. And I more point that out because I think that what it means is that we have multiple issues that you, as a leader of that department, are really grappling with, right? Which is some of it's cultural, some of it are norms, some of it are, some of it's even within the departments, like older ways of thinking about the ESA and old ways of approaching ESA. I mean, so it's kind of all around just sort of still a very knotty challenge. Dr. Smith, you were leaning in. I don't know if you wanted to respond to what I was just saying.
Well, I just wanted to join in and support you in your comments that the reason that we started CLT looking at the departments with regard to this particular subject of hiring had to do with the fact that we do have a cultural situation in the organization where understanding of the merit system rules and the memorandums of understanding and the state MMBA is not uniform, so that we felt that we'd need to start with the end users in order to begin to build some understanding that actual change depends on first doing the diagnosis and understanding the problem before we went to the central agency to follow up on process and procedures. The same thing was true with IT. We started with the departments first and then did the IT transformation. So it was done intentionally because
let me just say, I was actually told something different. I did not realize that was intentional. I was told that we had a lack of interest from the institution. I mean, different departments, because I thought part of your excitement around the whole leadership program was really getting people who were wanting to do it in the first place.
I guess I must have been inarticulate. What we tried as priorities is to strategically pick departments where there were early adopters or individuals that were really interested. Yeah. And then secondarily, we looked at strategic departments. So for example, Parks was very interested initially. Nobody's here from Parks.
You're being recorded, so be nice to Parks.
Yeah. They're great and they're important, but they're not strategically important to the entire function.
But they were enthusiastic about the opportunity.
Enthusiastic and were interested. We also pushed the hospital and health system, which are strategically important to the entire system because they're the largest department and their utilization of processes is critically important, although they didn't really start out as being all that super excited about change. So there were both issues
kind of coming together.
Right. So I must have explained it in the wrong way.
No, that makes sense. That's actually what I thought. I misunderstood your point. So, Dr. Smith, let me ask you this question, because you have raised a really important issue, and I know, John, you've been, I think you've been trying to kind of keep the peace between folks who feel unhappy with the processes of ESA, and then also keeping ESA's morale going in a good direction so you can make changes. So we're having a conversation that I recognize you must be, all of you must be thinking about kind of in real time all the time. But here's my question about it, about whether or not CLT can address the following issues, because I think Dr. Smith actually posed a challenge to me, and I hope you don't mind me being out loud with the challenge, but what Dr. Smith said was essentially, how do we know what target we're trying to hit? Like I maybe feel like you, Cindy, are moving the target on us, and which I think is fair, so I want to try to delve into that right now, because when I read the staff report and even the 3 items, I felt like that was not directly what I was thinking about as it relates to how we get what I think ESA, and I think this is true for labor relations, need to be where they need to be. So here's my question. Will CLT allow for a meaningful process map that can be presented to the board for an understanding of how, not just the board, but even the departments, how recruiting gets done? And the reason I'm highlighting that, not just recruitment, but how it functions, how it functions today and how it could function. Even with all the rules it has, there's still some interesting challenges. Like, I think it's interesting that after something goes through the budget process, it still needs to be requested from the department, because you've done a lot of upfront work already to get the job classifications, the titles, everything before us. We have laborious processes. Is there a way to circumvent that length of time? Do they just need to sign off saying we're ready to get through the process versus too much paperwork? That's just one example, but I'm wondering, could that be an outcome, even if that's not an outcome now, but could it be an outcome of CLT?
So yes, it could. And just to give you a little bit more background on the CLT process that we've embarked on, at least as it relates to ESA, I'm not sure if this is sort of how CLT applies generally in other parts of the county where it's been undertaken. But what the teams who have been constituted, as I mentioned, are working on now is sort of what we call this diagnosis phase. Out of that diagnosis phase, they're going to be developing work plans, basically. And the work plans are going to highlight the issues, say like with the HR team around recruiting, that they want to work on in partnership with the hiring departments who are feeding into this process and that they are in conversation with through the focus groups and the surveys. And then we'll be able to, as time passes and as we're evaluating our progress on the work plan, we'll be able to measure how far we've gotten on the various initiatives that we're focusing on.
So let me pose this question in a different way, because I think that's important, but what I'm really asking about is, so I think that's great. So let me just say that. And I think you're right that in some ways you've just got to, there's a lot of challenges and you've just got to get to each one of them as best you can. And I think that's a really good start, or a really good place to begin. Let me ask you this question. I have wondered both about labor relations and about HR as to whether or not we have done a recent enough assessment of whether or not we have the right structure to the organization, the right skill sets in the organization, and whether or not by doing business another way, you too would be undergoing a reorg and really kind of a deeper dive into how services are provided, and frankly, if based on the changes that are happening in the county, whether or not either additional training is required and or a new structure is required to respond to the needs of the organization.
So a couple of things that are kind of I guess, sort of auxiliary and in tandem with the CLT effort as we're envisioning it. Relative to the HR team, one of the components of that effort is that we have a solicitation out right now, I believe, to bring in someone who has public sector HR expertise who can help us address some of those questions that you mentioned about organizational structure and workflow and sort of what other entities do who might be recognized for best practices that can sort of in parallel to us engaging in this conversation with the organization writ large, we can also be thinking about sort of whatever recommendations and suggestions we're getting from this outside expert and how the two might interdigitate to help us get to whatever that future state's going to be. Same token with labor relations, we had requested and the board had approved as part of the FY19 budget, this year's budget, sort of a similar type of funding for a similar type of engagement, but specifically more focused on the organizational structure question. Like, what's the appropriate organizational structure for the labor relations function for an entity like us, like the County of Santa Clara, in terms of skill sets, how the work is distributed, sort of, the staffing complement and the level of support that we can provide to the departments. So that's also something that we're embarking on in terms of engaging someone to help us think through those questions too.
So here's a recommendation I would make on both of those. I think those are really good directions. I think for both HR and for labor relations, as you define the problems that you're trying to solve, like what is the overall problem we're trying to solve with both entities, that I would recommend get socialized with the board in any number of ways. You could do it committee or board-wide, and here's why. As I think about labor relations in particular, I've been fascinated by not understanding what our objective, not having an objective for labor relations. Like, in my mind, labor relations should be designed to create strong, powerful, meaningful relationships between the management and the staff that result in significantly improved services to the people we serve. But at no time since I've been here have I ever had any kind of, been party to any kind of discussion where that objective is identified, and then what are the implications of that objective. With ESA, it's the same thing. I think that the big, and these are much bigger, it's not just the some of the issues that you hear us stressing about are timing, but I want to know how everybody that we interface with leaves an interaction with us wanting to work for the county more versus the way I think a lot of people feel how they're interacted with, not responded to. And I would even say as simple as how we bring people downstairs for testing and how we interact with those people that are coming to be tested. I mean, I've watched us interact with them on occasion like recalcitrant school children. And that's not what we want, or we've just not welcomed them even into the building, let alone getting them ready to take a test for us. So from my perspective, those two high goals for both sides of the organization really should be defined and expressed in a way that allows for both for buy-in, but also for a perspective that's really much more countywide. And I'm sure you're getting that from Dr. Smith, but Dr. Smith is getting some feedback from the organization, but we also are getting feedback from the organization. And I think this is one of the few areas in the county that you'll see all 5 board members, and I don't think it's necessarily helpful to you, but all have an opinion. And I think part of what you, multiple opinions because of the way we interact with these organizations. But I think part of getting that wrestled to the ground is really getting buy-in. And I think you have to help us think about that. What I just said for labor relations is something based on, the fact that I've had a lot of experience on the labor side. But on the human relations side, I want people to want to work for us, and then when they're here, I want them, when they leave, to feel like we were grateful for their service. And I don't think we meet either of those marks in very broad ways yet. So those are my thoughts. Indulge.
Thank you. I'd like to ask a couple of questions about the countywide vacancy report and recruitment status, then jump back to it. And I'm trying to get just a better understanding. That's really why I'm asking the questions. I'm just going to pick a couple of items out. And I've got some hunches, and I want to see if my hunches, frankly, are well-founded or not. Packet page 561, which is item 18, page 7 of 10. There's a little chart there, very helpful. County communications, and it indicates that there is a 31.5% vacancy rate in the department. So while it's not a huge department, it's got a high vacancy rate, and I'm guessing by doing the math in my head that means that there are about 150 positions in the organization. And then what's intriguing to me is that of the 31% vacancy rate, which is 46 positions, 35 of those, or more than 3/4, are no request has been made. Now, I do notice that it indicates that it says ESA is working with the County Comms Department to develop a call taker classification as an entry-level classification in the Communications Dispatcher Classification Series. This will help training and retention issues that are contributing to the current vacancy rate. So how much of that is what's going on there? But I mean, it's, you know, when I see a piece of the organization that has, you know, a vacancy rate that's close to 1/3 of the organization, and then I see that 3/4 of that third is no request has been made, I'm saying, hey, what's happening there?
And I guess I should clarify that, you know, within that 35 vacancies, in order to give you a detailed answer, I would need to be able to tease out which positions and which classifications make up that 35. The broader context of basically in general why there's a high vacancy rate currently in county communications, as I understand it, from the operational perspective of the department, is that they are having a retention problem given the way the current communications dispatcher specification basically requires the dispatchers to be trained and know what to do in terms of taking the incoming calls and however those are managed with the computer system that they have, and then also be able to dispatch those calls to whichever entity or agency is responding. And so what the department has suggested and what we're now partnering with them on is basically creating what they're calling a call taker job classification to kind of sort of split those roles in two, so that we could bring someone in as more of an entry level as a call taker, train them on the aspects of dispatching that involve the incoming calls and processing them, and then the dispatcher would be able to then dispatch those calls to the agencies who would need to respond. So part of what this vacancy rate represents is the difficulty in training and retention and keeping people who can sort of manage both sides of that effectively. And part of what this represents is the department holding some of these positions vacant intentionally in anticipation of the advent of the call taker classification.
Let me add a little bit more from the operational perspective and connect it with the recommendations we have in the other item. As the board is well aware, we had, well, first of all of those vacant positions that are not request are not dispatchers. The majority of them are, but not all of them are. For the ones that are dispatch positions, as part of the analysis that we did with the department, we realized, as John said, that the job specs were a real impediment to actually filling the positions for a number of reasons, partly because of the training and requirements, and partly because of the of other issues that were in the job specs that required familiarity with systems that no longer exist. So this relates back to number 2 in terms of our 3 recommended actions. The job specs are being changed, as John said, and the job spec process or change process is an inordinately long process that doesn't need to be as long as it currently is, and that's why we suggest in item number 2 allowing the revision of job specs without the involvement of the labor organizations when there's no change to salary, so that we could have the authority from the board through changes in the ordinance code that would allow us to do these job spec revisions rapidly when it's clear that we need to do it. Because otherwise what happens is we do job spec revisions, we have a long meet and confer process that causes significant delay in the process. So that's, I think, a good example of how it connects with our 3 recommendations.
Supervisor Chavez, I see you leaning in on this.
And so just a side note to that, I think one of the reasons that I was nervous about that one is that we already get a lot of complaints that we don't do good communication with line staff to get their feedback. And so one of the problems, and I'll just use County Com as a really good example, because there's been so much activity that's gone through County Com in the last, I don't know, James and Dr. Smith, I think you both started to work on that. I know I was really interested in when I got here as well and weighed in quite a lot. But some of that is, from my opinion, is that if we had been listening even sooner to the line staff, there were some fixes that they recommended that ended up being invaluable to us being able to start to get back on the recruiting and training line. And frankly, I think one of our challenges is that we don't have the level of expertise on your staff necessarily in all of these different areas to always be able to give the appropriate kind of feedback for the overall approach of the way the jobs are structured. Now that's feedback that we've gotten from department heads. That's not feedback that I'm just recommending, and it is actually feedback from the labor movement too, that there sometimes seems to be a misunderstanding of the overall functions of the job or what the unintended consequences are to some of the changes that we're making to those jobs. Do you not think that's a concern, or do you feel like that's not a real concern?
I think what I would mention to the point that you made about getting feedback from line staff and employees, I think maybe one thing that might bear itself out through our CLT process is creating sort of more avenues of communication in our process to be able to get that type of feedback. Because currently the way our process works, and this is sort of related to the point you made about the feedback you've received from department heads, we don't make any changes to job specifications without their input and approval.
So their interpretation is that when push comes to shove, approval is on your side, not on theirs, and that has been consistent. And now whether or not that's accurate, that is a belief that has been conveyed through the organization. And it's a little, and let me also say, I recognize again that some of this is old cultural stuff. Like I'm not even saying that's still the case, but that is something I've been told as recently as, oh my goodness, I want to say in the last 2 months. I heard it when I first got here a lot, but I still heard it.
Well, Supervisor, when you're told that, tell me and I'll straighten them out.
Yeah, that's why they come right to you.
Yeah, they don't come to me.
No, I know.
Because the subject matter experts, who are the people involved with actually deciding what the employee is expected to do, are the ones that are relied upon. And ESA does not decide what the actual operations of the department are. That being said, they do cooperate in making sure that the job description is consistent with the rest of the organization. So for example, if the job spec is to change, as was mentioned in this region, to a new job spec where people just receive calls, the job spec has changed with the subject matter experts which are in the department, but the salary has to be set in such a way that it's consistent with our entire organization, so that they wouldn't get paid the same amount as somebody with a higher skill level, or they wouldn't get paid the same amount as somebody with a lower skill level. So, you know, if they do come to you and complain about that, let me know and we'll straighten them out.
Well, to be frank with you, the reason I haven't done that is that there's a little bit of fear around doing that, like around speaking up, particularly about ESA. I don't know why. Again, it could be cultural, and I'm just going to deviate just to make this one point. When I first got here, and it's still true, that we have a high level of concern in the organization around retaliation, and that people feel like they'll be fired or something bad will happen to them, even though we rarely fire people, as you know. I mean, so I'm not saying that everything I'm saying is accurate. I'm saying that this is the impression and the belief that exists in the organization about ESA, and there is a fear of speaking up, and I think that just needs to be acknowledged, because I think it will help address, you know, however the changes are that you want to make.
You're absolutely correct.
Thank you for letting me jump in.
And it is, you know, it is a cultural thing that we are trying to fix with CLT, but it's really challenging to fix that cultural belief. You're absolutely correct.
And I guess just to that point, and I'll take this opportunity since I'm being broadcast and hopefully lots of department heads are hearing me. You know, I don't have people coming to me, just like Dr. Smith said, he doesn't have people coming to him. And I guess I would welcome those types of conversations as an opportunity to be able to provide the context that Dr. Smith just provided about, you know, the fact that in our process we rely on job experts in the department to tell us, you know, well, what do you need this person to be able to have in terms of knowledge and skills and abilities and training. But then we need to be the ones to sort of embed that within the context of the larger countywide classification plan and say, okay, well, you know, given the employment standards, this kind of looks like this over here that's being paid this much. And so given the skill set and the scope, like we want to make sure that it's equitable across the county. And a lot of times I'm not sure that department heads realize that that's sort of the lens that we're looking at it with. And with good reason. I know that they, you know, have certain ideas about, you know, what they think should be appropriate in terms of compensation and why. And we just have to be able to have a conversation about that. So, I mean, I think it would be helpful to the extent that we were able to start to chip through some of that cultural stuff, because I think it would help everyone involved gain a better understanding of where each other is coming from.
I think this is a painful exercise, but I think it's a helpful and valuable one. Seriously, I mean, you got to have the conversation. So, but I want to go back to my somewhat narrower slice that I raised earlier, which was the county comms area, and I want to be clear. I'm using county comms only because of the numbers. I don't have a particular concern. But you know, I sometimes joke about, you know, if I had to explain this to a constituent on the street corner or at sidewalk office hours, you know, what is my easy, quick answer, accurate? And you know, if somebody came up to me and said, well, my understanding is your county communications operation has 150 spots more or less, but 35 of them are empty simply because no one's ever asked to fill them. How come? That's not a small number. And, you know, I understand the different answers I've gotten. I'm just saying, you know, in a 150-person organization, when you haven't even asked to fill 35 of the slots, you're going to have people like me saying, gee, that strikes me as not only odd, but counterproductive to realizing the mission of the organization. And then jumping over to social services on the next page, where the percent of vacancies is much, much lower, 11.2%. But of course, in an organization that size, that's a lot of people, 287. And the no request made number is large. It's 81 people. Now, again, 81 people in an organization that's probably, I don't know, 3,000 folks would be my guess. Not a big number percentage-wise, but I'm remembering the painful meetings that Supervisor Chavez and I had here about getting the CANS call center fully staffed, and I'm thinking, really, we've got 81 positions where somebody just hasn't said we want to fill the job. I'm trying to get a better handle on what that's about, and I understand that in some cases it's sort of pending. Well, we'll do that once we figured out what the new job classification is, or the new salary structure is, or the new whatever. But, at the risk of stating the obvious, stuff takes a long time to happen in the county. It just does. So, at some point, it's like, look, we got to fill these slots and do the work. We can't always be waiting till we're done, because we're never done, by virtue of the size of the organization, the changing mission of the organization, and the multiplicity of departments and agencies who do the work.
So John will be too nice, so I'll jump in. It is multifactorial. Different departments have different issues for not having a request in, as we mentioned. That's why, going back to the three magic bullets that we talked about, the first two really deal with most of the issues that cause departments not to request a position. Many times they have an intention to do an add delete later on, where they think that a particular open position is the wrong classification that they need for that particular job. And as you see, we requested some increased authority for administrative add deletes, because oftentimes the departments are saving that up for budget, or saving it up for some other time to go before the board. Again, job spec revisions are a big part of that. Anytime there's a job spec revision, it does take a significant amount of time, and we made some suggestions for ways to change that. And then another issue that you really touched upon, I think, pretty effectively, is that smaller departments with fewer managers generally have a harder time going through the personnel processes, because, as we said, managers are actually the people who are the hiring authority. They're the ones who have to put through the request to fill. They're the ones who need to talk to OBA about the funding. They're the ones who need to develop the transmittals to come to the board to create positions, all those kinds of things. And when you have a bigger department, you have a larger number of people dedicated to do the personnel issues and the HR issues. When you have a smaller department, there is a built-in incentive. It's not a good incentive, but there's a built-in incentive to just keep making do with what you got.
All right. We have the three recommended items under item number 6. Mr. Mills, my understanding, or my reading of this, is that you've not yet had a chance to sort of surface these with any of our employee groups. Is that just given the timeline?
That's correct, yes.
I think what I would suggest, Supervisor Chavez, is that we receive the report on item number 6, that we ask administration to have some conversation with our employee groups about the 3 items. I have no idea what the reaction will be. I do know that our employees are not well served either by having vacant positions. Short staffing doesn't do a lot for them. I have no idea what they would think of the trade-offs that are sort of embedded in these 3 recommendations, but I think it's worth another conversation at this committee and then forward it to the full board for some discussion. And so if we could get a motion to that effect, along with a motion to simply receive the report in item number 18, and anything else you want to add in the way of a request, obviously, Supervisor.
Yeah, and I would just say, John, if it's helpful to you to package maybe all of the reforms or the direction you're taking in one memorandum, so the board's looking at those items plus the other, plus CLT, what you expect to come out of that, you know, where you are in the hiring for your outside support. I just think that, you know, it's hard for people to look up all the links on all this, and that way everybody's looking at one full picture when we have a bigger discussion.
And Dr. Smith?
I love that suggestion. And when we do the CLT diagnosis and process, typically the teams present to me and the department heads what they're doing, why they're doing it. I think in this situation, if the committee doesn't object, I'd also ask them to come here and to present to you exactly what they're doing and why they're doing it, so you can actually have the insight of talking to them.
Great. So I believe I have a motion from Supervisor Chavez. It is to receive the report on both 6 and 18. It is to continue the 3 recommended items to a subsequent meeting of this committee, incorporating the presentations that have just been described, and then to advance the topic to the board for discussion and possible action there, all with the understanding that we're going to use some of the intervening time for you to tease out what the reaction from employees is likely to be to some of these where there are some trade-offs involved. Does that capture it all? So motion by Chavez, second by Simidian, without objection, so ordered. Thank you. I know that was a complex conversation. Thank you very much. That takes us to item number 7, which is to deal with the issue of procurement of inmate telephone services and tablets. Supervisor Chavez, at the last meeting, which we did as a committee as a whole, I spent a fair amount of time on this, as you might expect me to, and one of the outcomes was that Dr. Smith said, you know what, at this point, why don't we just budget for the phone calls to be free? That being said, we need to take action on this issue with a full committee present, which we have today, and I know that this has been an area of interest to you. I think I've been focused a little bit more on the telephones. You've been focused a little bit more on the tablets, but I wanted to make sure you got a chance to raise your comments, questions, and concerns today. I've sort of done my deep dive on this one at the prior meeting. Go to it.
Thank you. Oh, hello. Maybe if there's anything that's been updated that's not in our report, if we could just get a quick update, would be great.
Okay, good morning. Dan, you want to go ahead?
And if you'd all please introduce yourselves when you first speak.
Good morning, Dan Baldry, IT Director with Technology Services and Solutions.
Thanks. Go to it.
Alice Bailey, Director of Procurement.
Miriam Singer, Chief Procurement Officer.
And Duncan, Chief Information Officer.
Great. Okay.
So as we are in the midst of a procurement effort, I'm going to look to Miriam to assist us with some status updates on that.
I'll be happy to.
We also have the sheriff's office.
I'd like to share with the Board of Supervisors.
And if you could share directly into the microphone, pull it closer to your, there you go.
How's that?
Much better, thank you.
Very good. So I'd like to share that we are still in negotiation with a top-ranked vendor. We are working on refining the scope of work to ensure it meets the county's requirements. We are also working on service level agreements and language consistency, specifically Vietnamese language support. There are many areas and many details that need to be worked out, including price negotiations. And once negotiations are concluded, then we will be able to move forward with a recommendation for award. But there is still much work to be done in negotiations to ensure that the contract contains the necessary compliance and performance requirements in order to have a successful implementation.
And when you're talking about negotiations, you're speaking both of the calls and the tablets together.
Yes.
Yes. Okay. I just want to make sure that there's a lot of suspicious people, some of them in this audience, that have asked me about that. And then the second is you're in the midst of doing that, and so how you're a month away from this being completed.
I would say that with the holidays around the corner, we are striving to complete negotiations during the month of December. It depends on how well things go. and the timing and availability of the team and the vendor. This is one of the high priority procurements. So from the county's perspective, we are making all the team members available, and everyone is working collaboratively, but there is a great deal of detail to go through in order to ensure that the service level agreements include the correct information. And once we are able to agree on the words and the concepts, then the pricing negotiation component has to take place. So I would say with a very aggressive schedule that we would have completed negotiations in December, but there is a possibility that we may need a few weeks into January as well.
And could you say who is our negotiating team? And is it your office and the sheriff's office involved?
There are members of the procurement team, and there are members of TSS as well as the sheriff's office that participate on.
And then, I'm not sure if this goes to Ms. Duncan or not, but the Wi-Fi necessary for the jails, for some reason I had a spring time frame in my mind that both Elmwood and if we were having challenges in the main jail would be completed in the spring. Is that accurate?
Yes, but let me defer to Mr. Baldry for more details.
So at the moment, we are working with the Facilities and Fleet Department in order to finalize orders and plans for cabling within the Elmwood facility as well as the main jail. We have already received most of the equipment in terms of switches and routers and access points in order to install. It's mostly involving cabling labor, which we are doing everything we can to make sure it begins in January at the latest.
Sooner. Oh, that's great. And that would be covered, everything will be covered. We're not going to have some part of Elmwood or the main jail uncovered.
There's currently just some discussion about when we say all of Elmwood, what that actually includes. Whether
That's
that
an important discussion.
It is. It is a very important discussion. So we are working through that. At a minimum, all of the housing units and all of the building interiors where inmates will be housed or located are in scope. We're currently working with the sheriff's office to discuss some additional scope that's of interest.
What's the additional scope that's of interest?
The scope all along has been to provide Wi-Fi in every area where inmates would be. So I think what Dan is referring to is that if anybody is outside of a housing facility, they would require Wi-Fi access, because the tablets, obviously, if you're in the yard and you had your tablet, you would want to still be able to access the content. And I don't see that as additional scope. I would think that that was part of the original scope.
But it sounds like it's not part of the original scope from FAF's perspective and TSS. I'm trying to get used to your new acronym, but
That is correct. In the original evaluations, it was limited to the facilities themselves. So we have heard the sheriff's request, and we have a steering committee on Monday in order to discuss that further and see what the impacts to the project funding would be.
And that would be great to have come back to our next FGOC. I just would want to understand what that is and what the timeline would be for that. And then, and I did have a chance to learn some of your back and forth, and I guess I wanted to ask you a question, if you don't mind, since I didn't, because of the Brown Act, we really literally don't talk to each other at all, so you get to hear it all.
And for the record, I'm County Supervisor Joe Simidian responding to the question.
But you had raised some issues relative to, cost to families and the like, and I wonder how does, and I'm really asking a question, I don't know if you know the answer or procurement knows the answer, but is that a discussion that is being included as part of the negotiations, or is that something that needs to go to the board, or I just don't know what the next step on that is.
I don't know if you had a chance to listen to or see the conclusion of the conversation, but, and I'm not being flip here, I'm being almost verbatim, when I turned to the county executive and said, we're in the range of $800,000 to $1.5 million to just provide the phone calls for free. What do you think? And the county executive's response was, I think we've spent $1 million worth of time just talking about it. We ought to just do it at this point.
I did see that, but I didn't understand. Is that something that needs to go to the board because that's a policy discussion or not? I don't know.
It'll come in the budget if the board approves it. I mean, the committee has to forward a recommendation to the full board to move ahead with that. And once that's done, we'll just put the funding in the budget.
So you would like to Supervisor Chavez's question, and I appreciate it because I had perhaps incorrectly taken the conversational exchange to be, we've heard the message, we'll put it in the budget, and it sounds to me like you're saying we've heard the message and we're happy to put it in the budget if you just get direction from the board to do so.
Yeah, sort of in between. We heard the message, we're going to do it, and we're just relying upon the subcommittee to forward a routine report to the
Right.
board.
And I would like to
thank you.
surface, and it does make sense. I think it's a policy question about it. So I think that makes sense to have that go to the board.
Why don't we do it then as a report to the board, not as a request for action unless, or would you
Well, I
prefer
think
that it was a formal direction and an
Sure. Yeah, I
Okay.
think that. Now, here's a question for you all, timing-wise. I realize that you have told us you're in negotiations. We're having a discussion about negotiations, and now we're up here talking about both a resource and a change in the negotiations. Did I just say that accurately? Is that why you're panicking? No, I'm just kidding. I was watching you go back and forth. What I would like to request is that, Miriam, do you want to respond to that?
So we have 2 negotiations meetings that are set in December, and I believe that Alice Bailey, the Director of Procurement, can comment with more detail in terms of the dollar value that was expressed just earlier from the dais, in terms of how that might be impacted if we go a different way in terms of providing the facility of payment.
Good morning. The direction that we were going to move forward was to bring the contract as is, which is a zero-cost contract, to the board for approval, with the stipulation built in that we could go back for negotiations for President Simitian's request to look at either a subsidy or a full allocation in payment for the inmate cell calls.
Excuse the interruption. When you use the term zero cost, I think you're using it in the context of zero cost to the county.
That is correct.
As
Not
opposed
to the inmates.
Thank you.
Yes, sir.
And you're just getting into mechanics here. The board can go ahead and approve the contract, and we just subsidize it with budget out of the general fund. So
it's a core component of negotiations because how much we have to fork over from the general fund, it has a lot to do with how well these ladies do at the table, right?
Right.
So I understanding that, what I would say is since we don't actually know the value, this is kind of a stab in the dark up here, that what we bring to the board is a desire to have it be no cost to the inmates, but that we don't, that we want to reinforce for our negotiating team that doesn't mean that we want to see a bill, an inappropriate bill from whoever we're negotiating with.
Right.
That's all I want to make sure we say. Or
Just
if
so
it's a
that you're
change.
aware, we're looking at approximately $1 million a year of spend at the inmates' costs currently. So if we open this up and we allow all free phone calls, that number can exponentially increase because there is no control on the amount of calls that they'll be able to make. So even though we're giving you an estimate of what the projected contract amount will be, we really have no idea.
Right. Well, that's also based on a policy that we haven't yet passed. I mean, I don't mean just the free part of it, but how many minutes? What does that mean? Because I get that.
Yeah, and the board sets the policy. If the board wants us not to charge the inmates, we won't charge the inmates.
Right. But I understand the point that you're raising relative to that.
Okay. Anything else before I ask for a motion, and I'm going to try and craft a motion
Okay, let me
with
hear
you.
your motion. Let's go.
The motion is to receive the report and then to direct the administration to bring forward, and to forward to our board, excuse me. So to receive the report and then for our committee to forward to our board staff direction to budget for a no cost to the inmate policy understanding that, when we get to the budget process, we always have the ability to say, oh, now that we see what that number is, we don't want to go there. But with direction that is our policy preference. And I do want to speak briefly again to the reason for the policy preference. During the 6 years that I've been here, and again, everybody directly involved knows this has been a thing with me. My initial argument was, let's not gouge the inmates. And I think we made real progress on that, and I'm going to say thank you. That then got us to the no cost to the county, which meant that the inmates would pick up the actual cost. And now I'm not talking about no gouging, because we're not gouging, we're just actually covering the actual cost. But then there's a policy question, which is, do we actually want to incentivize people to stay in touch with their family and friends when they're incarcerated? And I'm saying, yes, as a policy matter, that's a thing I would like to support, and I understand that there is a cost for doing that. And then my parenthetical phrase as I look at our friends in law enforcement is, and yes, I understand that not every phone call is a warm and fuzzy stay-in-touch call, that sometimes those calls are used for purposes that we might frown upon. I get that. But as a general policy matter, I think it's to our benefit as a community to reinforce those community and family connections. That's just a policy judgment. I do have a card from Ron Hansen, and I want to call him up before we take action. But my motion would be, or the motion I would request, is to receive the report and then to forward a favorable recommendation to our board for a no cost to the inmate for telephone calls consistent with the model that's described here.
So, and what I would want to add is that that whatever adjustments or funding are necessary to complete Wi-Fi campus-wide in Elmwood that makes these tablets accessible outside the building be included in that action to the board, along with, if the staff knows there's a report time on when we would know when that could happen. And then the other is that I would just add is that I think that the intent is that I completely agree with the intent. I would just say I would be interested in getting input, particularly from the sheriff's office, about what the parameters of a program like that could and should look like. And the reason is that I did get a chance to read the report. I did get a chance to listen to your comments, and I'm mindful that there are issues relative to access to the phone, how long, your ability to listen to calls, the community's ability to give feedback if there are concerns or complaints about people getting harassing phone calls. Like all of that, I recognize needs to be thought through and vetted, and would like to get particularly the Sheriff's Department's input on how to address that. Is that okay with you?
I'm going to take that as a motion, and I'm going to second it. But before I call for a final vote on the matter, I want to go to Mr. Hansen, see if there's anything else that we should be thinking about factoring in here. Mr. Hansen, welcome.
Thank you. Good morning, supervisors. I guess it's afternoon, and committee members. I am Ron Hansen, affiliated with PACT, People Acting in Community Together. At the previous meeting of this committee, I and others commented that providing free calls for our jail detainees would be a net benefit for our county by, among other things, reducing recidivism by enhancing and maintaining contact with loved ones and others on the outside. At the same meeting, I was also encouraged to hear Dr. Smith's support of a free phone policy, assuming that it came with reasonable use controls. I look forward to this idea moving as quickly as possible from discussion to implementation. At the same meeting, several county representatives spoke of the great benefits in making tablets available in the jail. For over 3 years, I have promoted and shared this view with anyone who would listen. After a few false starts, an RFP for tablets was issued just over a year ago with an anticipated contract start date of May 8, 2018, 6 months ago. However, as yet, as we've just heard, no publicly established completion date for getting just one tablet into the hands of just one inmate has proven to be, it seems to be, an extraordinarily difficult task. In recent public meetings about the tablet project, I have mistakenly suggested that procurement efforts were gating the tablet project. I apologize. After conversations with those who do know, procurement is not the problem. Here in the heart of Silicon Valley, the tablet project is stalled, as we just heard, by cabling. I encourage this committee, as well as the Office of the Sheriff, to implement free phones in our jail, and also to exert whatever influence you may all have to bring to bear on moving the project, this tablet project, across the finish line. Doing so will benefit everyone. Thank you.
Thank you. All right, Supervisor Chavez, you have a motion on the floor. I have a second. Last call. Any other cards? None. Any other comments? Gentlemen, didn't want to preclude your comments if you have them to make, but you look like you're leaning back, not in. Okay. Then without objection, unanimously approved. Thank you all. Look forward to having a deliverable sometime soon. Appreciate it. That takes us, I believe, to item number 8 on our agenda. And Supervisor Chavez, this is the artificial intelligence issue that I know is of interest to you. So we've got a report from Dana Reed and from Ken Kenmana, and the requested action is simply to receive the report. How would you like to proceed?
Thank you. What I would like to do is, I just want to say I appreciate the report and the background information that was provided. On Tuesday, I'll be bringing forward a referral for the board to take a look at opportunities and new technologies that may be available for us to look at wildfires in our region. And what I'd like to do is just request that the staff attach this report to that discussion, because I think the discussion about the role of artificial intelligence will continue to be an issue. And I also think that there will be some, I think there's going to be a lot of, and I think your report reflects it, a lot on the horizon that we're going to want to be taking a look at as part of that. But I'd like to make it part of that broader discussion with our colleagues.
All right, then I'm going to call that, if I may, Supervisor, a motion to receive the report, which is the recommended action contained in our published agenda for item 8, but to supplement the receipt of the report with a request that it be attached to any related referrals from Supervisor Chavez at our very next meeting on
December 4th. Yes.
December 4th.
Sounds good. Need to make one correction, though, if I may, please, for the clerk of the board. The legislative file has Chief Kimna's name on it, and because we started this process with him, and actually the ledge file should actually have Chief Bowden's name on it for today's report, so I would respectfully like to call that correction, please.
All right.
Thank you.
We'll ask that the correction be made, and we'll see this item back in connection with the referral from Supervisor Chavez at our meeting of the board next week on Tuesday. Without objection, and seeing and hearing none, so ordered. Thank you very much. Thank you.
Thank you.
All right. And then that takes us to item number 11, which is the Sheriff's Overtime Report.
Thank you. Martha Wapensky, Deputy County Executive. With me today is Tracy Hess from the Office of Budget and Analysis and Tony Felice from the County Executive's Office. We do have a brief presentation, but given the lateness of the hour, we can go ahead and do that, or we can just take questions.
Supervisor Chavez, would you like to simply continue this item until the time when we can have a real conversation?
I would, and then what I would also like to do is I will forward to you and copy you, Joe, because I think it's appropriate to do that, a number of questions that we weren't able to get responded to as part of this report that I think are actually important for the discussion, if that's all right. Thanks.
Great. And sorry to keep you around today, but I know this is a big topic, and I don't want to give it short shrift, and I don't want to give you short shrift. So I think what we'll do is we'll say, without objection, continue to our next meeting of FGOC.
Sounds good.
Thank you. All right, and that will take us then to item number 12, which is the management audit of TSS, the one-year status report. And we made quite a bit of progress on this at our previous meeting, and Ms. Sullivan, I'm going to look to you. We did have a couple of items where we'd ask for some additional information back from the team if they could provide it, but also wanted to make sure, Supervisor Chavez, that you had an opportunity to weigh in on this topic if you were interested in doing so. Okay, Supervisor Chavez indicates that she's good with the item because we did spend quite a bit of time on this previously. My recollection is that I'd asked for a little bit of additional information in connection with 2.2, the hiring and classification process and the outside contracting activities, and specifically with connection to creating additional cybersecurity positions, and as to whether or not we should be creating those new positions before we were finished filling the existing ones. And basically, I was frankly concerned that, again, going back to earlier conversations, how long it takes for the system to work, that I understood the desire from the staff to say, well, let's do one thing and then do another, but I was a little concerned that that might make all this a little longer process than it ideally would be. So why don't you introduce yourselves and share what you'd like to share today and see where we are.
Ann Duncan, County Chief Information Officer.
Joyce Wallace, Chief IT Business Officer.
Justin Dietrich, Chief Information Security Officer.
Okay. Where are we on this cybersecurity issue at this point?
So for the hiring, we did submit a job requisition to hire for a contract position, and that's been posted, I believe, at this point, and just waiting for resumes to come in and review. The other two things I wanted to highlight that I might have forgotten to mention last time is to kind of supplement the audit functions. We had developed a partnership with the internal audit division to actually help us with auditing different departments for cybersecurity. So it wasn't that the function wasn't being done completely because of this partnership. And then also we had been doing a significant amount of hiring for the team as it was already. So we went, I think from like 6 people to 10 people. So it's been the whole time. It seems like we've been hiring or in the process. So didn't want to make it think that we were just kind of pushing things off too much, but trying to accomplish as much as possible.
Understood. I think you were obliged to sit through the conversation we had earlier in the meeting about no requests made. So I guess my question is, have we now actually commenced the hiring process for all of the cybersecurity positions, or are we still holding off?
So for 2 out of the 4, we've filled 1 position, and we're actually going to interview tomorrow. We've already set up the phone interviews for the 2nd position. The other 2 positions, I guess we're part of that no request made because the positions don't exist yet. So we have to develop those. There's no specific.
When you say that they don't exist, they exist as a budgeted item, yes?
Sorry, the position descriptions don't exist.
So let me see if I can help here. So Mr. Dietrich is waiting for ITCC positions, so he has requested and I approved the paperwork for a contractor. So he's going to use a contractor for at least one of those. You doing one or both?
One of them.
One of them? For one of them until those positions are available through ITCC. Is that?
Can we get a date certain by which we're actually going to just go hire these people?
So
I'm fine with the contracting. I remember that conversation from the previous meeting, and thank you. I thought it was a helpful way to say again, Dr. Smith, I'm doing my best to recall, and pretty much what you said is Supervisor Committee, and you don't have to choose between doing nothing and rushing ahead precipitously. We can go ahead and contract, make sure the functions get performed. But at some point, we're going to need to make a decision about are we going to fill these positions or not. And I'm trying to I don't want this to go into the black hole and never to be surfaced again. So 3 months, 6 months, 9 months, what's it?
So let me clarify that what he's holding for is the completion of ITCC. Our schedule for ITCC is we're in meet and confer right now, and we hope to be bringing something for you to approve in the spring. But it is contingent upon the meet and confer with the unions, which is why I'm reluctant to say Justin will be able to hire for this position with his new position description on this date because it's contingent on that. But our target is the spring.
If meet and confer does not go well, can we still fill the 2 positions?
So Mr. Dietrich could choose to fill the positions with a different classification that's not optimal at some point.
Or a contractor.
Right. He is using a contractor now.
Yeah. The positions, like I said before, the way that it's currently written, there has to be agreement. And the classification can be challenged, which is not necessary, but that's the same thing. That was number 2 in the recommendation. So I think realistically, we'll probably be continuing the contract service for a while.
A while meaning ballpark?
Probably 6 to 9 months.
Okay.
At ballpark.
Ms. Soloff, this is your audit. We're kicking around here. You got any comments you want to make before I offer hopefully my last observation?
Well, other than to just point out that I think that this issue is consistent with why there are so many, not submitted requisitions. These kinds of things are why the requisitions are not submitted.
Right.
Pardon my voice.
Okay.
But on this issue, I think they should move ahead with the contractor because this could take 18 months.
Yeah, that's my worry, candidly, is that we've got our best efforts and our fondest hopes and dreams and aspirations, and then we've got our hard experience behind us. And my hard experience tells me that in spite of everybody's best efforts, we could be having the same conversation a year from now, and I don't want to be there. So I guess what I would say is we're here today to receive the report. I'm going to offer up a motion to receive the report, and I'm going to ask that we get an off-agenda status report to all members of the board on this particular issue by June the 30th at the latest of the coming year. And what I'm going to say, and I know you know this, but I just, it's like, look, this is not a nice to have. This is a gotta have. Given the volume and sensitivity of the data we're responsible for, cybersecurity is not something that's just like, oh, that'd be nice. We have a legal and ethical obligation to take care of the data we've got. And again, I know I'm preaching to the choir here, but for those who are wondering why is Supervisor Sumitian so grumpy and contentious on this issue, it's because this is like saying we're not going to have a cop outside the door of the vault. It just so I'm pleased. So I should try and close on an up note here today. I'm pleased that we're going to find a way to make sure we get the job done using a contracting process. But I just want to be very clear that this is not something that we can 18 months from now say we just haven't gotten to it. And I'm also pleased, since I do want to end on an up note on this one, that we have made so much progress over the last few years. When I first came to the board, I felt that it was an area where the organization really had not sort of fully embraced the importance of cybersecurity and our obligations with respect to taking good care of the data we've got. I feel much, much better about that today than I did when I first arrived here 6 years ago for my second tour of duty, so thank you for all that. But I've got a motion to receive the report with a direction to provide an off-agenda report back on the status of this particular matter no later than June 30th. To members of the board, Supervisor Chavez, can I get a second on that? I can. Final request for comments, questions, if any? If not, then without objection, so ordered. Go forth and be secure, please. Okay. All right, that takes us to our next item. This is item number 14, I believe. And Supervisor Chavez, I don't know if you will recall this, but there was a board meeting or two where I expressed concern, and it's a concern that, if I recall correctly, you've also expressed at various times in various ways about the dearth of bids, and also about the fact that, in my experience and observation over the years, one of the ways people engage in bid rigging is that they essentially take turns. I'll win this one, you win that one, I'll win this one, you win that one. And so I asked, after expressing that concern, I asked Ms. Soloff to do a quick 40-hour audit pursuant to our process to say, what do you see and what do you think? And so, Ms. Sullivan, I know your voice is killing you, but if you can help introduce the conversation now, would be appreciated.
Thank you. Yeah, so I have with me today Alice Herr and Josh Ayler, who worked on this project with me. And I can give an overview, or
please do. If you're,
okay.
if you can make
Yeah.
your voice work, I think.
Yeah,
trying
no.
to pull some disparate pieces of data together here and answer this. So, what do we think? Question would be helpful.
So at the board meeting where this came up, you had a question about the controls around bid rigging, and then Supervisor Chavez had a different question, which was around the outreach program that, you know, the county is partnering with BTA on getting contractors in. So we took a look at both of those issues, and in a nutshell, the county's policies and procedures around controls for, you know, to prevent collusion are consistent with what's out there among other counties, consistent with state law, and as far as we know, there's no violation of those policies per se. However, once we looked at the detail and tried to gather up as much data as possible, we identified patterns that are consistent with bid rigging, which is not to say that we identified bid rigging. I want to make that very clear. What we found were, you know, hallmarks, indicators, markers for potential bid rigging. In some cases, using the data that was available, which is not data that was collected or necessarily intended for that sort of analysis. So we pulled together what there was, because no one is really tracking this, and no one is really doing an analysis of this, and I don't think that anyone had ever sort of backed up and just tried to take a look at what are the outcomes of the bidding process, which is what we tried to do. We tried to take a look at, well, what actually happened, what do you get at the end? And there were quite a number of instances where there was only one bid, really. A good, you know, quarter of the cases, and in addition, we identified that the outreach, while they have attended some outreach meetings through the VTA program, it's pretty much attending the meetings, not a whole lot going on there. So that could certainly be more robust. And frankly, I think it's a concern that there's really nobody tracking this carefully, and that there isn't any sort of overview, someone who can kind of take a look at this entire, you know, what are the outcomes, not just what is the control, but what's happening at the end.
All right. Anything else from your team?
No.
Okay. Supervisor Chavez, I've got some thoughts, but I want to go to you first.
Oh, thank you. And I'll let you maybe dive into the bid rigging, and then I want to just talk about the board policy outreach to minority vendors, and maybe what we can do to kind of fast forward some more robust implementation. And Dr. Smith, I know that you have raised some concerns about this, and also, you know, been really, I think, very thoughtful about kind of pushing the organization to think about how we do a better job of minority outreach on for bids. And I also know that Supervisor Cortese on a number of occasions has raised the issue about, like, what kinds of strategic actions can we take to make it easier to get local businesses and minority-owned businesses and women-owned businesses to engage with the county. And so to that end, you know, I know I'm hoping that what we can do is get an external partner to help us take a look at it, because what VTA did originally with an outside vendor was really restructure their outreach process, and it's tremendous now in terms of getting local vendors. And I know you and I at different times have met with the consultant who did that work for them. And so maybe you could give some thoughts about how we can bring that consultant over directly to us to lay the groundwork for us to be doing what VTA is doing.
Yes, Supervisor, as you know, we initially tried to subcontract with VTA to take advantage of their program. That didn't really work out. So actually on the December 4th agenda, we have a referral from Supervisors Yeager and Cortese recommending a pilot program with the Minority Business Consortium. And so it's asking for staff to come back with a report and suggestions, and we've been working with the supervisors to be prepared to respond to that. So I think we're moving ahead on exactly what you're talking about.
Good, good, good. And then, well, actually, that's great. I'll wait till we have that discussion with the board.
Then I guess the question would be, Dr. Smith, looking at the suggested improvements that the Rose organization has put forth, which are at packet page 355 or page 11 of their document, would that be an opportunity, if it's coming on this Tuesday, to ask if we could have you come back with your recommendations in connection with these 4 suggested improvements at the same time? I don't want to steal somebody else's referral, but on the other hand, I don't want to make this a more, more moving parts than it needs to, or are these really disparate issues?
I think they're different, yeah. Yeah.
They're sort of different, plus I don't think we could have anything substantially new by next Tuesday. I would ask that maybe you let us come back in January with that information.
Okay, do you think we could take it to the full board in January, or do we want to bring it back through committee first? I don't have.
No, we could go to the full board.
All right. Well, then, I think what I'd like to do is simply say thank you, receive the report today, ask the staff to come back with a set of recommendations in January to our full board. Ms. Solov, I'm going to ask you to stay engaged on this in terms of looking at the staff's reaction to your suggested improvements, and I'm hoping that by then your voice is improved and you can weigh in fully in the conversation. Okay? Supervisor Chavez, motion to that effect?
So moved. Thank you.
All right. Motion by Chavez, second by Semidian, without objection. So ordered, and thank you again to the team. Much appreciated. All right, on to our next item. Dr. Smith, mindful of the time, Supervisor Chavez, what's your thinking on this one?
Countywide contracting, right? Let me catch up.
Strikes me that countywide contracting probably isn't a 5-minute item.
True.
You want to simply defer this one to our next meeting?
Yeah.
I think
Sorry, Miriam.
not ideal, but that's what we're going to do, just again, because it's an important one. And then that would take us to the final items, I believe. Yes. So we're going to, without objection, for the record, we'll defer item 21 to our next board meeting. 22 is on consent. Item 23 is to receive a report from the Office of the County Executive, Chief Information Security Officer, and the Registrar of Voters relating to county election and voter security matters, and then a possible recess to executive session. If we could have folks come to the dais on this one. And since we have you here, and this item is agendized, I'm going to first ask, as a contextual matter, without going too far afield, I'm going to ask the registrar to introduce herself, and then I'm going to ask her, is there anything she can share with us about the status of the vote count and potential recounts coming our way? Yeah.
Shannon Boucher, Registrar of Voters. Well, status on the counting, we have completed
the provisional counting, the remaining provisional ballots will be in today's release of results. We're able to look at the recounts after tonight's release as of what we believe will be in the recount, but I have to make it very clear that voters who did not sign their ballots, voters who have a signature different on their envelope of their ballot or provisional different from the signature on file, we call a mismatched signature. Every one of those, we have sent a letter and said, you can provide us your signature if you missed it, or give us your new one or correct it. Those are not due until December 4th by law into our office, which is next Tuesday. So I just want to make aware that the final counts will not be certified till December 6th. We would need to include any letters received by the voters that we received through 5 p.m. on December 2nd. At this time, I estimate 5 recounts, but the final numbers will be next Tuesday. But I was going to be sending the board an email with that update next week. But so right now, my guess would say 4 to 6, but probably 5. Okay. But that's about where we're at on the recount.
And my recollection on this issue, which we've spent a lot of quality time on together, is that where we landed as a board for the final policy, or at least final as of this moment, is that we do a recount if it is less than 25 votes separating a winner and a loser, and if we're at 0.25%. And what I can't remember, and I'm not asking you to tell me right now, but I want to ask my staff to follow up with you later today and your staff, is that 0.25% is a kind of a more difficult calculation to make in multi-candidate races. And I know we talked about this previously and sorted out how we were going to do that. I just don't remember what the outcome was.
Well, you are correct, less than 25 votes, so we're looking at 24 and under, and it is less than 0.25 of the ballots cast, not of the votes cast. So yes, some of those we are, like the measure HH, that'll probably be in the recount. We take the ballots cast and divide, what it would have taken to win the 66.667%, et cetera. So we have some that are teetering right at the mark of 24, 25, 26, 20. So we will also be looking at the write-in vote report that'll be coming later today. And this is why it's very important that we will need to look for any of these letters coming from the voters with their signatures, because I'm right on the border for some of the potential recounts.
All right, and since you were kind enough and thorough enough to remember the distinction, so as I understand it then, if there were 10,000 ballots cast for a 2-seat position, 2 seats on a school board or a city council, and there could be 10 different candidates, but what we're looking at is whether or not the difference between the winner and the loser is less than 0.25% of the total number of ballots cast, which in this case would be 10,000 ballots. If there were 10,000 ballots cast, never mind that they could have all voted for 2 people and that there were 20,000 votes. Did I get that right?
Correct. It is between the winning and the losing candidate.
Yeah. And then is there anything that either of you can or would like to share about the security of the election? There doesn't appear to be, if I understand we can't talk about a lot in public session, but if there's nothing anybody should be worried about and you can say that out loud, that might be a good thing.
I will say from our end at the Registrar of Voters, all of our online lookups, all of our information, social media, we did not encounter any issues.
Ms. Dietrich, anything you can say?
I echo that and did not encounter any issues.
Did not encounter any issues. Did I hear that correctly? Good. All right. Thank you. Then what I'm going to do is ask that we go to item 24, which is to announce prior to our recess to closed session. I'm going to turn to Mr. Williams, see if he's got any language that we need to enter into the record in order to do that. And then after what I anticipate will be a brief recess to closed session. We'll come back out, and we will reconvene for a closed session report, if any. Mr. Williams?
The committee will meet in closed session to discuss item number 25 as listed on the agenda for the November 29, 2018 FGOC meeting.
All right, then we stand in recess, and I anticipate, as I say, that it'll be a brief meeting, and then we'll return for a brief announcement as to action taken, reportable action taken, if any. We stand in recess. Thank you all very much. This is the Santa Clara County Board of Supervisors Finance and Government Oversight Committee. We are now reconvening an open session for a closed session report. And I'm going to turn to the County Counsel, Mr. Williams, to see if there is any reportable action. Mr. Williams?
There were no reportable actions taken at the November 29, 2018 Finance and Government Operations Committee closed session meeting.
All right, thank you. Then, in the absence of any report, we will move to an adjournment. We are adjourned now to the next regular meeting on Thursday, January the 17th at 2 p.m. in these board chambers. Without objection and hearing none, we are adjourned. Thank you all very much.